I see. What will be listed for withdrawal tomorrow, my lord?
Withdrawal.
Withdrawal, my lord. Tomorrow, of like.
May I please, your lords? Item number 43, lords.
43.
So we are going to file our affidavit in opposition, lordship. We have served advance copy to the petitioner side, lordship.
Okay. Yes.
After 10 days, we'll explore the option of filing it.
After?
10 days, my lord.
Okay. Mr. P. Vardas, Learned Counsel for the petition is present. Mr. N.K. Sharma, Learned Counsel, representing Mr. H.K. Das, Learned Standing Counsel, Guwahati High Court, has submitted that the counter affidavit on behalf of the respondents will be filed during the course of the day. A copy of the said affidavit, the counter affidavit, has already been served upon the Learned Counsel for the petitioner. Post of as sought for and as I agreed to by the Learned Counsel for the parties, list the case right. Maybe 27.
Lords.
My lord, I have prayer in item 34, my lord, of today's case, my lord. There are two I, my lord. I have filed, my lord. In my lord, the petition, my lord. The petitioner is also no more, my lord, and the private respondent, my lord, he is also no more, my lord. His legal hairs have been, my lord, impleted, my lord, in both the IAs, my lord. Lord, will you be pleased to kindly take it about 2 p.m., my lord.
After motion.
Hmm.
After motions,
Motions.
doesn't appear to be any
My lord. Will you-
urgent nature.
Another prayer, lords. I paid for listing of the one matter, lordship, matter for admission, lordship. Pleadings are already complete, lordship. Lordship, may kindly take up this matter and next week any day, lordship.
Silence.
My lord, I beg to mention a case for listing. Actually, thing is, this case has been listed last 17th July 24, and there was an order to list it after 3 weeks. Since then, it has not been listed.
Hmm.
If this court be kind enough to list
What is
it,
the subject matter?
it was Graptree Company Limited versus State of Assam.
Subject.
That instruction is not with
Huh?
me, though.
What is the issue involved?
That is not to me. I beg your pardon.
Okay, Friday, next Friday.
Is it possible to do it in the, December 3rd or 5th?
December.
5th or
Okay,
3rd?
5th. No, I don't know about the subject matter. 2nd of December.
Black.
Please, your lordship, I beg to mention item number 11. The concerned officer is on leave, so we are awaiting instructions in that regard. So some
Lordships,
will be granted.
Lordships, I beg to appear in 11 on behalf of the petitioner.
Yes, Mr. Kanodia.
Lordships,
Yeah.
Lordship, this was regarding the sestet order was passed way back in May, and we had represented 4 times to the commissioner.
About rate. About
the
rate.
special rate, Lordships.
Hmm.
It is already sestet has passed the order in May, and after that we have given 4 representations. They are not acting on the sestet's order.
Okay. Now, concerned official is out of station. He's saying he's seeking some accommodation.
Lordship,
When?
21st, I am coming physically. If your Lordship may be pleased to keep this 21st.
Okay. This is
Grateful.
motion. You come on
Motion.
22nd.
Lordship, 21st, Lordship, I am there in Guwahati for some.
22nd. Okay, Mr. A. Kanodia, Learned Counsel for the petitioner has appeared through video conferencing. Post of Mr.
K. Jain,
K. Jain,
on
Learned
behalf
Counsel.
of SCKL.
For?
On behalf of SCKL.
Okay. Learned Counsel representing Mr. S.C. Cal and Standing Counsel GST has sought for an accommodation till 22nd. List the case, the price allowed, list the case on 22nd.
Grateful.
Motion. Okay, motion.
Much of
Please, your lordship. Lordship, I pray for listing of matter today, your lordship. The matter relates to eviction of the petitioner, your lordship. The petitioner is a patadar occupying the land after purchasing the land through registered deed of sale, your lordship. And thereafter constructing a RCC house over the said plot of land after obtaining due permission, lordship. Now she has been served the eviction notice, and the date is of today, lordship, 13th.
Have you filed already?
Yes, I have given filing, lordship.
Okay.
May I plead your lordship, in
Objection.
item 53 of today's list, your lordship, we have filed a compliance affidavit regarding justice service yesterday, your lordship. Record may be called for.
Okay.
Oblige.
May I please your lordship? I'm for 47, item number 47. but
Item number 47.
Your lordship, we have filed an IA today. That is need to be called on record.
I. Okay.
May I please, your lordship, here on behalf of the.
Then, oh, yes, madam, it is not I to be listed. This is not the way. 47.
Yes, your lordship.
Then get it listed some other day. Monday. Along with the I. Yes, MS.
As they.
As they, Learned Counsel for the petitioners has submitted that an interlocutory application has been filed in this writ petition. And the writ petition may be listed along with the said I on Monday. List the procedural is the case on Monday, along with the interlocutory application stated to have been filed.
May I please, your lordship, here on behalf of the finance and taxation, we have filed 5 writ petition. And the connected matter is fixed on 1911 and seeking lordship permission to.
You are filing writ petition.
Yes, we have.
Okay, 19.
Yes, connected matter is fixed on 19th.
Okay.
Maybe little lordship. I beg to mention from listing the WP matter, writ petition matter,
Order, admission,
It-
motion,
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 motion.
Monday.
Another lordship.
You have already filed.
Yes, yes, lordship.
File over.
Lordship, I pray for listing of a writ petition for admission on Tuesday, your lordship.
Not Tuesday. Without checking, I do not allow. No Tuesday, Thursday.
Then,
Only after my satisfaction, I.
lordship, then Wednesday, lordship.
What is it?
I pray for listing of a matter of the motion hearing tomorrow, lordship, if possible.
Tomorrow not possible. For this court, it is not possible.
That's two, lordship.
That is also
Friday is holiday.
not possible.
Friday is holiday, that is my lordship.
Tomorrow is not possible. Otherwise, I would have allowed.
Today at two, lordship. Today at two, lordship.
What? Admission?
Motion.
No, what? Oh, motion? Okay, motion. Motion. Okay, tomorrow.
Oblige.
May it please your lordship. I beg to mention item number 54, supplementary list lordship.
54.
54.
Yes, sir.
Okay, I may be allowed to withdraw with a liberty, lord. Yes, madam. What's a land acquisition matter engaged?
Am I correct or wrong?
Yes, lord.
Huh?
You've gone through the judgment.
Nandini?
Yes.
Okay, I'll do you 54. Okay, I am granting him liberty. Mr. S.J. Sharma. Heard Mr. S.J. Sharma, Learned Counsel for the petitioner, B.D. Decca, Learned Counsel for the caveator, stroke respondent number 6. Mr. Siburu is available. Okay. Record the name, Siburu, Learned Standing Counsel, NHI, so-and-so. M. Borman. Mr. Sharma, Learned Counsel for the petitioner, has submitted that the petitioner may be permitted to withdraw this writ petition in order to writ petition preferred under Article 226 of the Constitution of India in order to prefer appropriate application under Article 227. An appropriate application to assail the judgment and judgment dated 22/5/2024 passed by the court of Learned District Judge cum LARR authority at Jorhat in LA reference case number 02 of 2022. This is NH Act.
Yes.
On a reference made under section 3H within bracket 4 of the National Highways Act 1956. Full stop. Will not record that. Non-genius should be recorded.
Let it remain because there are some High Court judgments which have said a revision under 115 may also happen.
Okay,
So let that be
okay.
discussed.
Yes, yes. There is no appellate provision.
There is no provision.
Any checks? The prayer made on behalf of the petitioner is not objected to by the learned counsel for the respondents. Post in view of the above submission made by Mr. Sharma, learned counsel for the petitioner, the petition stands dismissed on withdrawal with the liberty as prayed for. You go through the 9 judges bench. Naresh. Yes.
I beg to mention two identical acting, my lord, regarding forest royalty lordship is heard on several occasions, my lord. Maybe listed in the next week, my lord.
I am not sure about my situation.
Yes.
Whether I'll be here or not. You make a mention tomorrow.
Tomorrow. Yes. Tomorrow. Oblate.
Yes, sir. What are the adjournments to be yesterday, Lordship, on behalf of Mr. DJ Das, Your Lordship?
Mr. DJ Das.
Commitment regarding this matter, I am doing few cases regarding House Committee, Your Lordship, regarding this contempt case also, they have submitted some telephoning instruction. And this present Chief Executive Officer, he is no longer as Chief Executive Officer of the House Committee. And accordingly, I have some instruction also, verbal instruction also. That
Verbal or written?
verbal. Yesterday only I got.
Okay, okay. What to do? Mr. Mazumdar is available.
We're informed that they will take an adjournment.
Okay, okay.
Next week, Your Lordship.
Then when it is listed, you make a mention because he may have to change the name. Otherwise, if I issue notice again, it will go after 4 weeks. Okay. Mr. Shall I keep your name in the cause list?
Your Lordship, it's up to the Lordship, Your Lordship.
No, I'll just record. I'm not issuing notice. So it will facilitate you to appear on the next date.
Yes, few cases.
Get the written instructions so that petitioner will be benefited.
And present incumbent is no longer as Chief Executive.
Okay. Somebody else will be there.
Yes, yes.
You get that
Already-
instruction also.
Yes, yes.
It will be difficult for him to obtain that instruction.
Every new incumbent also.
Right? You furnish him, you help him,
Yes, sir.
assist him. Okay, Mr. N. Gautam, learned counsel appearing for Mr. DJ Das, learned central government counsel has submitted that Mr. Das has some difficulty today and the case be listed after a week. Post of it is submitted by Mr. Gautam that consent has already been taken from the learned counsel for the petitioner to make the prayer. Post of list the case accordingly on next week. Ms. K. Fukon, learned central government counsel has submitted that she has received some instruction about the constitution of about the present composition of the House Committee.
Yes.
Present,
Status.
about present status of the Chief Executive Officer. Chief Executive Officer
Regarding instruction also. Your Lordship.
of the House Committee of India. And post up and the same would be submitted on the next date of listing. Post up list the case accordingly on so and so. Procedural list the case on so and so. The name of Ms. K. Fugan, Central Government Council, be also reflected in the respondents in the call list.
Maybe the lordship in this matter, previous.
House Committee,
Yes, my lord.
Eh.
Similar matter, my lord.
you want same date?
Yes, my lord.
Your Lordship,
Otherwise,
Your Lordship, here this present income is no longer as Chief Executive Officer. Some Najim Ahmed is in his place, Your Lordship.
if I issue notice,
Yes, my lord.
it will be of no purpose. Have you understood?
Yes, my lord. Yes, my lord.
You are Mr. M.S. Soikia, Mr. M.S. Soikia.
R.I. Bhuya, my lord.
Where is M.S. Soikia?
He is my senior.
Is he available?
No, my lord.
Hmm?
Now.
Because it will be same,
Yes,
will
yes.
issue notice. Nothing will, no purpose will be served.
He has
If-
to implement new incumbent, your lordship, Nadim Ahmed.
Nadim Ahmed is here.
Yeah.
No, Liaquat Ali here.
Liaquat
Ali
Ali
is
is
no longer
Ah.
as chief executive officer.
What to do?
My lord already.
You have written instruction,
Wakalatnama, they have sent, your lordship. You can go through, your lordship.
but it is a contempt case.
Yes, yes.
Yes, my lord.
The previous one, regarding previous annual, your lordship, we can kindly go through this.
Oh, you have received. Oh, Mr. Counsel, better you withdraw this, implement the new one. He is signing it. On the day itself, she may appear. Discuss with your senior.
Yes, my.
Come back.
Yes, my.
Come back after some time.
Yes, my lord.
No, I will issue notice. Then new incumbent will come or it will not be responded.
Will be lying down.
Case will be lying without any purpose.
Okay, my lord.
Have you understood?
Yes, my lord.
She will furnish the details of the present chief executive officer.
Yes, my lord.
You implead him, file a new petition. That is what I am saying. Get your instructions from your senior.
My lord.
Okay.
Okay.
Item 3.
May I please, Your Lordship? Lordship, willful and deliberate violation of order dated 14th.
Heard. Mr. Rasayakan, learned counsel for the petitioner. First off, this contempt petition is filed stating that there is deliberate non-compliance of the direction passed in an order dated 14/6/2024 in a writ petition WBC number 5314/2022. Issue notice returnable in 4 weeks. The petition shall take steps for service of notice upon the respondents by registered post with AD within 2 working days.
Lordship. So, Lordship.
Item 4.
Right, please, Your
M. Hussain. Direction. Order dated 17/11/2023. WBC number 5406/2022. Returnable 4 weeks. Steps registered post within 2 days.
Item number 5.
M. Hussain. Direction order 5/8/2022. Writ petition number 4997/2022. Registered post with AD within 2 working days.
So, Lordship.
6. Item 6.
Yes. Mr.
A. Mondal.
A.
Mondal.
Mondal,
On behalf of BS.
representing Mr. B. Islam. Direction. Order dated 8/4/2024. WBC number 1934/2022. Steps by registered post. Notice returnable 4 weeks. Within 2 working days.
Item 7.
May I please?
Asayakand. Ex gratia.
Yes.
Order dated 5/6/2024, WBC number 2269/2024. Returnable 4 weeks. Steps by register post within 2 working days.
Mr. Grateful.
Item 8.
P. Hazarika.
Order dated 6/8/2020.
6/8/2024. WC number 7082/2023. Private respondent?
Yes.
Why?
My lord, there is a direction to dismantle this gate, my lord. The inquest,
Agreement arrived at. There was counsel for respondent of 5
my
there.
lord.
Okay, steps by registered post. Issue notice return in 4 weeks. Steps by registered post. Within 2 working days.
Public.
I think that item number 2. I inform with my seniors, so I will file fresh filing.
Mr. M.H. Sorry, your name, please.
R.I. Bhuya.
R.
I. Bhuya.
I. Bhuya. Learned counsel for the petitioner had, The instant contempt petition is preferred against non-compliance of the direction made in the order dated 22/5/2024, passed in the writ petition WBC number 1884/2024, full stop. On the previous date of listing, Mr. D.J. Das, Learned Central Government Council, was asked to obtain instruction. And para 3, para 4 likhe dibo. Para 3 and para 4 likhe dibo. Para 3 likhe dibo. On the previous date of listing, that is on 6/11/2024, the Learned Central Government Council was asked to obtain instruction as regards receipt of the representation by the Chief Executive Officer, Host Committee of Chief Executive Officer, Central Host Committee of India, Mumbai, Maharashtra, post of para. Today, MSK Fukan, Learned Central Government Council has submitted, on instruction, the sole respondent impleaded herein, namely, Mr. Liaquat Ali Apaki is no longer holding the post of Chief Executive Officer, and in his place, one Mr. Spelling N-A Z-E-M Ahmed,
Yes.
has joined in the post of Chief Executive Officer, Central Host Committee of India, Mumbai. Post of. In view of such instructions placed by the Central Government Council, Mr. So-and-so Learned Counsel for the petitioner has submitted that the petitioner may be permitted to withdraw this contempt petition and to file a contempt petition afresh, impleading the present incumbent Chief Executive Officer, Central Host Committee of India. Post of. In view of the above submission made by so-and-so Learned Counsel for the petitioner, this contempt petition is allowed to be withdrawn. Accordingly, the same is dismissed on withdrawal with the liberty as prayed for.
Number 9.
Yeah, please, your lord. My lord, under instruction, I am to submit that the appeal was not received by the petitioner, my lord. The appeal was never returned to him, my lord.
Have you read this one?
Yes, my lord. How they have sent this?
Where is Mr. B. Deka? Did you file any first appeal?
Yes, my lord.
Huh? Let us see your case. What is your section 6?
Page 23 may
14.2.
kindly be seen, my lord.
14.2. To designate public service district officer. Have you supplied any copy of the petition to Mr. Deka?
His name is shown, my lord, in the
Huh?
first. Yes, we defined.
Name is shown.
Yes, corresponding one.
Can you call him because some confusion?
Okay, sir.
Because he has preferred first appeal. He have preferred first appeal
My
before the
lord.
Deputy Commission. But State Information Commission has furnished information instruction that they have not preferred first appeal. Please call Mr. Deka.
Number 10.
Please, Lordship. This honorable court has called for instruction from respondent authority regarding doc number 214.
Yes. So it has neither been acquired or encroached upon. That is their stand.
constructing continuously, Lordship.
Maybe you are believing that that tag number is 214.
214, Lordship.
Maybe you are believing that the land you are occupying falls under tag number 214.
Lordship, 214
Because
is
whether this they will
not giving any prior notice, Lordship. We have.
no question is
Lordship.
otherwise, so far as all records are concerned,
Lordship.
this Latmondal circle officer, they are better positioned than you, right?
Lordship.
So far records are concerned and GPS location are concerned.
Lordship.
And you may be under the belief that the land falls under 214.
Lordship.
They are saying circle officer with responsibility, he is saying that it is neither been acquired nor encroached upon. That is a statement of a state government official of a higher rank, additional deputy commissioner revenue. He is saying from the office of the deputy commissioner, see your statement.
Which plot we are?
Hand him over to a copy. Where is your any document substantiating the fact that you are in occupation of 212 and 214?
Lordship, kindly see pages, annexure number 218 page.
18.
18, it is a khas land 214. I have my forefathers and I inherently occupied from 1986, Lordship. I have bona fide claim, Lordship.
How much is the area?
18 bigha, Lordship. 9 bigha is already.
No, under 214.
214, 9 bigha, Lordship.
9 bigha is also not permissible to be allotted under land policy also.
Lordship. But I have bona fide
You
claim.
cannot legitimately claim
Lordship.
9 bigha
Lordship.
under the land policy
Lordship.
as a landless person. Yes, madam. Disputed questions of fact. He is saying that Skill University is occupying, and you are repeatedly saying that we are not occupying. What to do?
Lordship,
If otherwise, if they have encroached upon, you have to go for a civil suit.
Right.
Writ petition is based on what? Affidavits. From the affidavits, if disputed questions of fact are emerging, what to do? We cannot go there and find out.
Lordship. Lordship,
Everything
my
will be
humble
prolonged
prayer
hard,
before you,
Mr.
Lordship, kindly teach
Sagwal.
another date. I will show the photograph.
You have already shown.
Father photograph.
Sitting here, we cannot decide this.
Lordship.
Sitting here, we cannot decide this. Which one is 214, which one is 212. Circle officer, they are repeatedly saying,
Lordship.
we are not into 214. Our university is only up to 213. Is it not?
Lordship.
They are repeatedly saying that 213, we are up to 213, including 212. And you are saying they are into 214.
Separate claims.
In view of such statement, we cannot do anything at this stage. Additional Deputy Commissioner is saying, and why? Who is Himalaya Sharma by name?
Lordship, he is.
He is Deputy Project Director, Lordship.
He is in official capacity, he is going there. Why you are making him a party? Has he trashed you?
Lordship, he is interfering the matter, that is why.
As an official, he is a Deputy Project Director of a government project.
Lordship.
It is not his personal
Lordship.
intervention. It is his official intervention.
So he is personally intervened the matter, Lordship. That is why we make party.
You implement Deputy Commissioner also. Additional Deputy Commissioners, Circle Officer, everybody by name. Lat Mondal, Kanon Go, Chainman, make them parties. What kind of ever went against him? Show me. You think it over, Mr. Hart, Mr. Viso, and so first paragraph. Oh no. On 4/11/2024, this court has passed the following order, para 2, 3, 4, 5, 6, 7. MS Bormon has placed, General Junior Government Advocate has placed a communication bearing number so and so, dated so and so, of the additional District Commissioner within bracket Revenue, O/O, the District Commissioner Dorong Mongolway, addressed to her. First, as per the said communication, the plot of land under DAG number 214 of village Gerimari Sapori under Rongamati Moja has neither been acquired nor encroached upon for the Assam Skill University. Post Mr. Khaklari, learned in view of such instruction, Mr. Khaklari, learned counsel for the petition, has submitted that the matter be listed on next Wednesday in order to complete his instructions. List the case accordingly on switch.
Item number 12.
In this case, on last occasion, I was supposed to put some notification.
That mistake, some kind of mistake, they are saying. They are saying.
That is fact.
Mistake they are saying.
The room was provided to them
Huh?
from 1/10/2022 to 30/11/2022 on the basis of Supreme Court judgment.
Yes.
That is reflected in the appellate order also.
Yes.
But we come to page 103.
One thing is clear that there is no suppression or any kind of thing there,
No,
but amount is also there. Amount is there, but from here he
they could not rectify
he incorporated somewhere else.
on the basis of Supreme Court judgment. The room was provided to all the SCCs, but they didn't avail this opportunity.
So you missed the bus.
My lord, at that point of time, when Supreme Court directed this, at that period, we tried to avail or rectify this, but our portal was not then being operated.
Which portal? Their portal.
Actually, we could not access there. We verbally.
This is Bharwell.
No, my
This
lord,
part is Bharwell.
my lord, whatever it be, money is there. The
Right.
ITC is there. As per the
Now
order
Supreme
passed
Court
by-
has provided the window.
Undoubtedly, my lord.
And now you said you encountered difficulty, so you mentioned it Bharweli. What to do now?
That time we,
You get the period extended from Supreme Court.
my lord, that is not the issue. Issue is,
I cannot extend now.
So that is reflected in the appellate order also. They missed the bus. That is reflected.
What is the period window provided?
Was lordship
19/2022 to 31/10/2022. Thereafter, further it was extended
For another month.
another
So
1 month.
State Appellate Tribunal is constituted or not constituted?
Probably it is constituted.
Huh?
It has been constituted.
Then why should we entertain?
My lord, the whole dispute pivots around an entry, whether it would be in 5A.
No,
or
no, I have
7B.
understood.
Yes,
Now, like you, others had also encountered difficulties. Others, right?
Yes, my lord.
And matter reached the Supreme Court. That
Yes.
is what,
Yes.
right? And Supreme Court, considering the fact, situation, had asked the revenue
Right.
to open the window for some more period,
Yes, my
right?
lord. Yes, my lord.
And other SSCs avail that extended period. But it is you who missed the bus. And now your excuse is oral. Oral
That-
prayer glitches. Now, which is not possible to be.
My lord, I am not entering into that.
Ah.
Undoubtedly. On natural justice, or my lord, kindly come to para number 4 of the Supreme Court order.
Where is the order?
I am
Is it part of the pleading?
that is at last second page.
What was the issue there?
My lord, the issue is on this, on transitional
Uh-huh.
ITC. Last second page
What?
from the end. Fourth, para number 4. The
Is
concept
directed to
officers
open government portal for filing concerned forms for availing transitional credit to train and train for 2 months.
pass appropriate orders on merit, my lord.
Considering the judgments of the High Court on the prevailing people, any agreement register is directed to file a element for reverse already filled from respect of whether taxpayer file a petition with whether the case satisfied. GST has to ensure that there are no technical glitch during the time. They are given 90 days thereafter to verify the various details. Now, which paragraph?
Fourth, paragraph number 4.
This was an order passed on which date? Hmm?
On 22nd July 2022.
Where it is reflected?
Page 38.
Page 30.
38.
38.
Yes, my lord.
22nd July 2022. We are 2 years, 2 months more. Okay. On that day, GSTN directed to open common portal for filing concerned forms for availing transitional credits through train and train to for 2 months up to 31st October 2022. Okay.
Plus further extended for another month.
Another
1 month.
1 month, meaning thereby
30th of November.
November 2022. Considering the judgments of the High Court on the then prevailing peculiar circumstances, any aggrieved registered SSC is directed to file the relevant form or revise the already filled form, irrespective of whether the taxpayer has filed writ petition before the High Court or whether the case of the taxpayer has been decided by the ITZ so and so, so and so. So, you fall within that category who did not file any writ petition.
Yes.
Right?
Yes.
So what happened when your demand comes so cause notice?
Let's say page 103 may be kindly be queried.
I'll see. Just let me. It was on which date? Demand comes so cause notice.
No.
When it was?
9/2/2020.
Where is the page?
Page 41.
Page 41. The date?
That is at the end, page 49.
Page 49.
9/2/2022.
Okay, 9/2/2022.
My lord.
Yes. Then what did you did? After receiving this, you replied.
Yes, my lord, we
You
submitted
replied.
the reply.
Good. Then
Then
reply is running up to page 52, 72.
72.
Thereafter, hearing.
Thereafter, final order. Why?
Final order, record of personal hearing. Personal hearing was there.
Yes, my lord.
It was on 7/11. At the time, the window was open.
Yes, my lord. Here we submitted what is the problem going on. But when the portal is not giving us the access, then how can I prove that portal is not giving the access? We tried. We complained about the matter before the authority. Repeatedly, we submitted these facts before the authorities.
Come to page 73.
70. Yes, my lord.
What you are submitting in addition, third para, to the earlier submission dated so he further stated that by the Honorable Supreme Court record of proceeding for special leave to appeal so point number 1, 2, and 3, pages 46, referred to in connection to the case represented by him. What you were saying?
My lord, they are also.
You are aware about this proceeding or what?
Yes, we are aware.
You were aware.
Yes, my lord.
Then what? Why you did not avail that opportunity?
My lord, repeatedly I am submitting before your honor that time we tried to.
Where is the
resolve
effort?
issue. Yes, my lord. What? Yes.
Where is the effort that you are repeatedly trying, that mentioning it? Because your submission was in different line.
My lord, we wanted to submit that when we have submitted that in 5A and it would be 7B. So they are admitting that the aggregate amount of ITC undoubtedly in with the
Yes,
department.
sir, but you have been given the window to submit a revised form. Is it not?
Undoubtedly, my lord.
Undoubtedly.
Yes, my lord.
So what is your?
My lord, my prayer before your lordship is that when the money is with them, they are asking us or passing the order to reverse the ITC, but that amount is within the department. That's why we are praying before your lordship for natural justice, that when the money is with them, they are again asking reverse it and pay interest and penalty. Now the fact is that when the money is there, can an SSE be?
Now, Mr. Upadhyay.
Mr. Bhattacharya.
Roadside. Now the ordering appeal was also passed on 14/11/2023.
Yes.
Now, why you were so late?
My lord, from that time I am submitting before your lordship and before
from 14/11, where you are not submitting before me.
no.
Please.
Right at this moment.
Right at this moment. But what about 1 year? Where you were submitting?
We submitted.
Sir, there, even if an appellate remedy is available, and that is not possible, suppose, for non-constitution of the tribunal or whatever, a writ petition is to be filed within the period of limitation.
No, my lord.
A writ
Actually-
petition, Mr. Counsel, please answer to my query.
Yes,
Otherwise, everything is to be given a quietus.
my lord,
That is also the law.
my lord,
What is that decision?
my lord. Kindly,
That if a writ petition is to be filed, if filed, instead of availing the remedy of appeal, then the court, while entertaining the writ petition, has to see that it is filed within the limitation period of appeal.
my lord,
And it is not filed.
my lord, I am coming. Kindly
Please,
turn to page 111. Thereafter, the assessing authority issued a notice citing therein to meet the end of justice. Yes, my lord. Kindly, second paragraph, unnumbered second paragraph, page 111. Please refer to your letter this in response to this office letter event number 03 dated 14/3/2024. This is to inform here that to meet the end of justice, the undersigned has fixed a date for personal hearing on 15/5/2024 at 12:30 hours in the chamber of the undersigned in the aforementioned office. We attended that. There we submitted our reply. We wanted to know when the matter is already decided by the appellate authority, then can your authority for issue us such type of letter or notice wherein your authority is sending us that they are calling us for the ends of justice. That is.
then come to
pages
page
before.
109, Mr.
Yes,
Bhattacharya.
that is our.
Who has asked for personal hearing?
Yes, the superintendent. 108 before that. That is the notice at page 108. Taking that notice, getting that
This is to
notice,
inform the
we
midnight of
submitted.
just under the fixed date of friends in the chamber. He is
Page
superintendent.
108. is the-
He is superintendent. This is now.
My lord,
it is-
he is the authority who passed the OIO, order in original.
Now, after
Challenging his
ordering original, this proceeding is not to be taken cognizance.
My lord, kindly.
We'll issue only notice.
You are
at
therefore,
this stage.
second paragraph, my lord. You are therefore
This
requested.
is to be given a quietus. After 14/11/2023, you are pursuing somewhere else.
My lord, they are asking us to appear before
You
the
know
Honorable
about the
Court
law.
of Justice.
After passing an order in appeal, what the
That's-
original adjudicating authority
that-
can do.
that's
You
why-
should know. You are a tax assessee, mister.
My lord, that's why.
You are a
we
tax
sub-
assessee. You are and represented by an authorized representative, legal representative. You are pursuing the matter there. Now you have come. After trying to adjust there, then you have come. It is too late now. It is to be given a quietus.
My lord, in that case, I will pray before your lordship to kindly allow to file a supplementary affidavit before your lordship.
Will
to
issue
control the
notice,
deal.
no interim order. I tried to find out whether premises satisfaction can be reached, but your conduct is not in support of
My lord,
that. Yes, that is a bona fide mistake. I know, but window was open. You did not avail that.
my lord, we could not. If
That
we
is-
could, if
That
we
is
could,
show
my
me in
lord.
black and white, Mr. Bhattacharya. Show me in black and white. after order in original, you preferred appeal and you were aware of the proceeding. It is not that,
We are aware.
yes,
That's why, my lord,
but
we are
you
submitting
insisted that my demand should be fulfilled. That is what,
My lord,
that is what
I am,
the
what I am
appellate
submitting for
authority
your,
has recorded, Mr.
my lord, what
Okay,
I am
we'll issue
submitting
notice.
for your honor,
We'll decide.
that they are illegitimately claiming whether I have committed an error or not. They are the adjudicating authority. They are the appellate authority. Money is with them. Maybe
After,
I have, maybe I have
Parasati,
filed.
after order in appeal, why you have waited for 1 year almost?
My lord, thereafter.
There is no excuse in your case.
Kindly, my lord, in that case, I allow to file a supplementary affidavit condoning the, allow to condone the delay for the ends of justice, my lord.
No, that is not permissible. That is what said the Supreme Court. You must be aware. I have forgotten the case name.
I'll provide.
Huh?
I'll provide a place.
I have forgotten the name of the case. You don't have any idea. Tax people? Huh? That is a judgment of the Supreme Court in tax matter. You are supposed to take the plea, but nowhere you are taking the plea. And that is, if the appellate period, the people are coming here after exhausting that writ petition. If the appeal is provided in the statute, they are coming violation of natural justice, all this. This kind of writ petition is to be preferred within the period of limitation or extended period of limitation. Otherwise, it has to be given a quietus. Let us stop this. That is what Supreme Court has heard. Mr. A.S. Bhattacharya, Learned Counsel for the petition, assisted by Mr. D.J. Kapil, Learned Counsel for the petitioner. Mr. Cal, you represent whom?
Lordship, and 1 to 4.
K. Fukan, Learned Central Government Counsel for the response number 1. Mr. S.C. Cal, Learned Counsel for the response number 2, 3, and 4. Mr. B. Gugul, Learned Standing Counsel, Finance and Taxation Department for the response number 5. Full stop. The petitioner in this writ petition has assailed an order in original dated 6/2/2023. Annexer, bracket 10. And an order in appeal dated 14/11/2023. Annexer 12. In addition to a demand cum show cause notice. Annexer 7, dated 9/2/2022. Poster. Issue notice returnable and so and so. But steps as so and so within 2 working days. Pay for interim relief is kept open for consideration for stuff on the next date of listing, returnable date.
Finding the item number 9.
9. Yes, Mr. Deka.
Sorry.
Your name is reflected.
Yes, sir. No, I was coming.
sudden traffic in Demolition.
Now, as per your instruction, he did not prefer any appeal, first appeal.
That's why
Do you have a copy of the writ petition?
we did not have the copy with us, with the commission at the time of filing the second appeal. Information with regard to filing or not filing was not with us. So we have returned it, asking him. to
Page
submit.
24.
Now we can see. That's all, it's the first appeal. So he comes with the copy to the commission, fulfilling whatever the requirement, we can dispose of the second appeal also. As we have sought for the deficit documents, he can submit it to us and we'll dispose it.
You prefer the second appeal?
As per the.
State.
As per the letter, if you submit.
Yes.
whatever-
Only time frame may be given for.
Yes, Lordship, within a time frame will dispose.
So it is a fact that it has been returned.
We have returned because we did not have the copy of the first appeal.
Okay. Anyway, we will not record, but you file a, because it is a fact that he has preferred a first appeal. So you give the details to him in the proper form, right? Page 24 is to be included that Deputy Commissioner had entertained the first appeal under section 19(1). You give the facts, otherwise how can they know? Heard Mr. S. Alim, Learned Counsel for the petitioner. D. Deka, Learned Counsel for the respondent number 1, and MS M. Bormon, Learned Junior Government Advocate, Assam, for the respondent number 2 and 3. Full stop. The petitioner preferred an application under Section 6 of the Right to Information Act 2005, seeking certain information Mr. Deka, check one judgment of the Supreme Court. Cooperative society, they are not public authorities.
So, cooperative society is not a public. Kerala High Court also has decided.
The Supreme Court is there.
That's gone.
Well written judgment.
And even honor, this High Court also coordinate bench decided.
When the thereafter, he stated to have preferred a first appeal under section 19(1) of the RTA Act 2005. And full stop. Subsequently, he approached the Assam Information Commission by presenting an application highlighting his grievances in respect of the information he sought for from the public information officer. Full stop. This petition is preferred, seeking inter alia writ in the nature of mandamus for direction to the respondent authorities to furnish the required information to the petitioner in terms of his application under section 6 RTI Act 2005. Application dated 14/2023. Full stop. Mr. Teka, Learned Standing Counsel for the Assam Information Commission. Respondent number 1. No, 2. 1, 2. 1.
1 minute.
1. Not 1, wrongly written. Wrongly written, State of Assam, for the Assam Information Commission. Standing Counsel, Assam Information Commission has submitted that the commission had received the application of the petitioner as the application of the petitioner was bereft of the details as regards his approach before the first appellate authority under section 19(1) of the RTI Act, comma, and the application was not in proper form. The said application was returned by an order dated 15/12/2023 to the petitioner. First of, Mr. Alim, learned counsel for the petitioner, has submitted that the petitioner has not received any order dated 15/12/2023 from the commission. First of, para. Any limitation period is there? No.
There is limitation period, however, that may be controversial.
If an applicant is aggrieved by the decision or indecision of the public information officer and the first appellate authority, comma, he has the option of approaching the State Information Commission by way of a second appeal under 19(3) of the RTI Act 2005. First off. Without going into the disputed without going into Mr. Alim at this stage, Mr. Deka has submitted that if the petitioner approaches the commission by way of a second appeal in a proper form, along with all the necessary documents.
Response to the letter that we have.
In response to the letter dated for 15/12/2023, comma, the such second appeal would be considered and would be considered in accordance with law. First of, in view of such submission made by the standing counsel, Assam Information Commission, comma, the petitioner, Mr. Alim, learned counsel for the petitioner, has submitted to the petitioner would approach the Assam Information Commission by preferring a second appeal under section 19(3) of the RTI Act in proper form, along with all the documents relating to his approaches before the public information officer and the first appellate authority. First of, in view of taking note of the submissions made by the learned counsel for the parties, this writ petition, this court is of the considered view that instead of keeping this writ petition pending, comma, the same can be disposed of with a direction, with an observation that, permitting the petitioner to approach the Assam Information Commission to by preferring a second appeal under section 19(3) of the RTI Act, along with all the supporting documents relating to his approaches before the state public information officer and the first appellate authority. Full stop. It is ordered accordingly. Full stop. It is further observed that in the event the petitioner prefers an appeal under section 19(3) of the RTI Act, it is expected that the Assam Information Commission will consider the same and on its own merits and in accordance with law.
One time frame may be given for disposal of the.
Within 15 days, you approach.
I will approach. But the disposal, my lord, disposal.
Mr. Deka will ensure. And is expected, huh? And disposes of the said second appeal with utmost expedition.
Right, my lord.
Preferably within a period of 3 months.
I'm highly obliged.
Item 13.
Installment.
My lord.
Yes, installment.
Lordship, we have received instruction in this case. Lordship, installment was earlier granted to the petitioner.
Yes, that I know.
This is my written instruction.
It is mercy now.
Lordship.
No, all are the same thing. Anything about mercy?
That depends upon the law. It will up to your lordship.
Then we have to at least, you should notice at least this. You file.
Conduct lordship, lordship paragraph 7 may kindly see.
Yes, SARS and CJ means something.
No, lordship, thereafter they applied for paying tax.
That I have.
Installments. But
He failed. He
paid
failed.
only one installment, thereafter default.
Failed.
Thereafter courtesy action was taken.
In the meantime, a rectification was there, my lord.
Huh?
In the meantime, rectification applications were filed. Rectification applications, my lord, they were
Huh.
filed. And the orders were rectified, my lord. After rectification,
Some 10 lakh reduced.
this, my lord, but the installment were not adjusted with these things, my lord.
Yes, it is a paragraph 7 lordship. It is there.
Yes, my lord.
Paragraph 6 and 7 of the thing.
Since June, you are paying nothing.
In the month of June, we paid 19 lakhs, my lord. Thereafter, my lord, we could not, because my lord.
19 lakh or what? What is the installment granted to you?
My lord. Lordship, I have given the chart, my lord, at page 7, my lord, paragraph 6, my lord.
Now, where is the order granting 10 installments?
My lord. Page 50 onwards, my lord.
Page 51.
My lord.
So if you have paid 19 lakh, then from this order, only remaining amount should be 9 lakh.
No, my lord. 19 lakhs is the installment per month, my lord. There are four different.
Demand, no, you are taking me to page what? Which one?
My lord, in page.
Okay, in every case,
Different.
okay,
amount.
different installment
Yeah, Lord.
amount.
Amount.
And finally, that means total 19 lakh.
19 lakhs per month.
And total liability is what?
1 crore 72 lakhs.
My lord,
Now it has become,
one
okay,
crore-
1 crore 72 lakh.
We requested for 24 installments, my lord. Since it was very difficult on our part, they granted 10 only, my lord.
Hmm.
And my lord, in the meantime, all our bank account has been freezed, my lord. We will not be able to conduct business if, my lord. So I'm paying for, my lord, granting at least, my lord, 18 installment, my lord. So we have sought for 24, my lord. 18 we will be paying without any default, my lord.
Okay, we can issue short notice at this stage. Otherwise, without response from
Then,
the revenue,
my lord, only one.
we cannot, from my side, I cannot do it. After receiving affidavit, we can
Then, my lord,
direct.
because my lord, lordship will just kindly see pay 101, my lord. I have given a chart, my lord, where I have to make this payment per month, my lord, including EMIs and salaries, my lord. Page 101, my lord.
100?
101, my lord. Annexure E, my lord. This includes, my lord, bank EMI, staff salary, ESI, EPF, electricity, transport expenses, everything, my lord.
Okay, we will put them on short notice, but it is a proceeding taken as per law. The installment part is not there.
Then, man, I'm
You
paying-
asked for
my lord.
24, they have granted 10.
Then, my lord, only one submission, my lord, with regard to case credit account and overdraft account, my lord. That I am paying, my lord, that they cannot freeze, my lord.
Yes, what about that?
Okay, instruction.
My lord, I can place the judgment of all different high court,
Ah.
which says, my lord.
That is what he was saying also on that day
My
also,
lord.
that this is will not be property. It is bank money. I think he was saying that.
Yes, my lord.
Take your instruction that's regarding this part,
My lord.
regarding opening of the cash credit account. Because he was saying that day also.
Yeah, my lord, in Monday. Can it be on Tuesday, my lord? Monday, I have some difficulty. But tomorrow,
Wednesday then.
only instruction regarding case credit cannot.
Wednesday.
Lordship, my lord.
Heard Mr. R.S. Mishra, learned counsel for the petitioner. M. Bormon, learned counsel representing S.K. Medi, learned central government, M.S. M. Bormon. M. Bormon? For respondable and Mr. S.C. Kyle, learned standing counsel, income tax department. Mr. Kyle has submitted that, no, sorry. The petitioner has approached this court by the instant writ petition to assail a notice dated 23/10/2024. Page
103, my lord. And total there are 3 notices, my lord. Having same date, my lord. 103, 106, 109.
under section 226 within bracket 3 of the Income Tax Act 1961, whereby, oh, another one.
Yes, ma'am. There are 3 notices, my lord.
Oh,
Page
the notices, huh? Notices. Dash, huh? Dash divider 1 likibo, notice dated 23/10/2024, annexer H, comma, notice dated, all dated,
my lord,
same.
Same, my lord.
Okay, comma, notices, 3 notices, comma, all dated 23/10/2024, within bracket, annexer H,
My
Z,
H
and I. Issued the petitioner under section, issued under section 226 within bracket 3 of the Income Tax Act 1961, drawing recovery proceedings against the petitioner for an amount of
Page 111, my lord. 111, my lord, below, my lord.
This is one only?
1 crore 87 lakhs. All the notices contain same amount.
Oh, okay. For an amount of rupees 1 crore 87 lakh 56,390. Full stop. Mr. Mishra, learned counsel, what a petitioner has submitted that after the on conclusion of the connected proceedings, the petitioner made a prayer before the respondent authorities to allow him to submit the demanded amount in 24 number of installments, as the same would allow the petitioner to operate the business and to generate the revenue to deposit the amounts to the respondent authorities. Full stop. He has submitted that the respondent authorities had allowed only 10 installments instead of 24 number of installments as paid for. Full stop. Furthermore, and the same has created difficulties for the petitioner to deposit the installments regularly. Full stop. He has further submitted that in the process, bank accounts,
My lord, page 10, my lord.
page 10. How many?
My lord, 8.
8 number of bank accounts of the petitioner have been attached. Full stop. Out of those 8 bank accounts, 6 of them are savings accounts. And the other 2 bank accounts are cash credit account and overdraft account. Full stop. It is Mr. Mishra has contended that so far as the cash credit facility and overdraft facility extended by the bank to the petitioner cannot be termed as a property of the petitioner to be attached. Full stop. And in such view of the matter, he has sought for an interim order, interim relief. He has contended that the respondent authorities could not have attached those 2 accounts. Full stop. We take instruction about this. Mr. Kyle Lanet, standing counsel, GST, has submitted that he would complete his instructions about such contention of the petitioner regarding attachment of bank accounts having overdraft cash credit facility and overdraft facility. Full stop. As sought for and agreed to list the case on Wednesday.
It will be the income tax.
Huh?
In place of GST, it will be.
GST, no, income tax. 1961, huh? You take that judgment.
I lord, given, my lord. Item 14. 14, 15 are same, my lord. They were supposed to open instructions in the meeting.
Let it be on Friday. Next Friday.
Next week Friday. Okay. A.K. Gupta, R.S. Mishra, Learned Counsel for the petitioner, and Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department for the respondents are present as sought for by Mr. Gogoi. List the case on key date.
22nd.
22nd. Next is same?
Yes,
14,
14, 15
15
same.
Same.
Number 16.
Yes, your non-application of mine. Huh?
Lordship, in this case, Lordship, I have got today, Lordship, all the books, all yes.
A non-application, let me. Cannot turn it is clear reflection of non-application of mine. That you cannot escape. People are jeopardized by your typing mistake. This is not permitted. We'll keep it in abeyance because of non-application of mine, clear non-application of mine. If you put something, persons are put in the mental agony. If I am served with a notice for 1 crore without reflecting the details, how can we know? Wrong details. This is complete. You take your instruction, file your affidavit. Hard. MS and Havelia. We are not going into the limitation point at this stage. Since it is a college, had it been a company, I would have disallowed your petition. Dr. Gogoi, you represent all?
Yes, Lord.
Dr. B. and Gogoi, Learned Standing Council GST for all the respondents.
Income tax department.
Huh? Oh,
Income tax department. Lordship is very much akin with the GST.
No. I learned from the councils. Okay. The petitioner, number 1, is an educational institute and is a regular SSC under the Income Tax Act 1961. Full stop. Para. The petitioner was served with a notice under Clause B of Section 148A of the Income Tax Act by the ITO, page 38 of Sabo, W-1 within bracket 2, Guwahati, stating that information at his disposal is suggestive of a fact that the income chargeable to tax for the assessment year 2016-2017 had escaped assessment within the meaning of Section 147 of the IT Act 1961. And the details were furnished under page 59 or table quantitative. Full stop. After the petition number 1, sought time on 2/3/2023, a similar notice was issued by the ITO W-1 within bracket 2 Guwahati on 15/3/2023, allowing the prayer of the petition number 1 for time. Full stop. Subsequently, a notice again under Clause B of Section 148A of the IT Act 1961 was issued under the hand of Ward 23, page 63, exempt Guwahati, reiterating the fact that information suggested that income chargeable to tax for the assessment year 2016-2017 had escaped assessment within the meaning of 147 of the IT Act. And the details as in Annex 1 to the notice dated 21/2/2023 was made part of the said notice. Full stop. Though the petitioner did not take part in the proceedings, purportedly undertaken by the respondent authorities. The respondent authorities proceeded to pass an order under Clause D of Section 148A of the Income Tax Act, IT Act 1961 on 12/4/2023.
Lord,
Regarding following financial transactions during the financial year 2015, that's 2016, relevant to the assessment year 2016, that's 2017, page 65 or 66 or table considio. After reaching a satisfaction, comma, the ITO Ward 2-3 exam, Guwahati. Found the case to be a fit one to issue notice under Section 148 of the IT Act 1961. Full stop. And thereafter, comma, the petitioner was served with a notice dated 12/4/2023 under Section 148 and followed by an intimation under Section 144B on 8/5/2024, right? Full stop. A number of Ms. Havelia Learned Counsel for the petitioners has raised a number of contentions. Full stop. One of such contention is that while the notice under Clause B of Section 148A of the IT Act 1961 notices were issued for financial transactions shown in the annexure therein, comma, the order under Clause D of Section 148A of the IT Act was passed in respect of complete different transactions about which did not pertain to the petition number 1 college, right? First of, and it goes to show that there was non-application of mind on the part of the assessing authority. First of, issue notice returnable on to ensure that as Dr. Gogoi has appeared and accepted notice on behalf of all the respondents, no formal notice. First of, having regard to the financial transactions appearing in the notice under Clause B of Section 148A and the order passed under Clause D of Section 148A of the Income Tax Act, comma, the proceeding taken by the assessing authority is primarily suggestive of non-application of mind. First of, in such view of the matter, comma, it is observed that till the returnable date, there shall be no coercive action against the petitioners.
It is dated 12/4/2023.
Notice dated
12/4/2023.
12/4/2023. As the is in terms of the notice dated section 20 is dated 12/4/2023 under issued under section 148 of the IT Act, as the same is in continuation of the order under clause D of section 148A of the IT Act.
Time may be 5 minutes.
Date I have given.
1812.
Extra copy two or same.
That Drawn earlier one.
Okay, that the same.
Same. But you will find the page number 21 is the guideline of the scheme. Clause 6.4.2.
6.4.2.
May I read, Lordship, this?
Yes.
DLEC will be responsible for carrying forward the objectives of the mission for project formulation, implementation, and monitoring. The office of the DD within bracket J/JD within bracket A, EE, and A shall be the district nodal agency with the following functions. Identify the areas of low ratio farm power availability areas with larger number of small and marginal holdings for implementation of farm mechanization components. Identify beneficiaries, farmers, self-help groups, SHGs, user groups, cooperative societies, farmer producer organization, and entrepreneurs to avail the benefit of the SMMAM in the transparent and time-bound manner. Identify the entrepreneur/SHGs to establish custom hiring centers. So, Lordship, this from the rule, one thing is clear, that the scheme shall be implemented in area where the farm mechanization weapons are used in low ratio, and the beneficiary are the marginal farmer. Now, my case is that in violation of the guideline, the benefit is given to some persons, that is the SHGs, who cannot be said that a marginal farmer, a person who is having a property of 1.5 crore and landed property spreading throughout the country, he is not entitled to avail the benefit of any farmer scheme. And that, Lordship, will find that the select list is there, page number 41.
41.
41 is the select list.
Hmm.
41, Lordship. I am not targeting that organization or that person. I am just referring because there is a violation, because there are so many violations, and I have noticed this one, that the TC Hitia SHG, SAG, that is Agricultural Service Group, which is an SHG.
Okay.
It is represented by its president.
Self-help group.
Self-help group.
Okay.
Odesh Kumar Singh, son of late Gurkhanath Singh. And this beneficiary is the contesting candidate of the ruling party in the assembly election of 2011. In next year also he has contested, but I did not annex the relevant documents. And which is, Lordship, will find that in the page number 43. Name is same, affidavit that I have obtained from the official website of the Election Commission of India. That I, Odesh Kumar Singh, son of late Gurkhanath Singh, the same man, and his property is...
Property having more than 3 crores.
Yes.
Yes, MS Bora, you are selecting beneficiaries.
The scheme is of the central government, not government of India scheme.
But selection part is by...
Chairman of the district level executive committee is the collector, Lordship, and
yes, they are
state level is the principal.
District level, I think he is showing from page 21 that page 20, what? Page 20?
21. Lordship.
1. It's showing that
DLEC
the
will be
DLEC, District Nodal Agency,
Page 20, Lordship.
Page-
6.4,
6.4,
6.41.
41 district level. So Deputy Director Agriculture,
It's the member secretary.
Member Secretary,
Director is the chairman. The chairman.
Collector, basically state government official, they have been funded from central government. But selection of beneficiary is entrusted to state government official, district level.
DLEC is a
Hmm.
nodal agency.
This is one. And your group
Lordship.
was selected, not selected.
No, that application was submitted, but the selection process they have done and without informing anybody or without hearing of the party. This is the process. Then when
Okay.
the list published, I came to know that some people are given benefit, those are not supposed to be
Okay.
not entitled.
Yes, MS Bora.
Lordship, I'll get my instruction. Notice maybe.
Okay.
And Lordship,
Right.
till they get instruction, no further decision may be taken in terms of the select list.
No, we don't know the select list so far as only this particular farm. This is, you have implemented response number 5, right?
Yes, Lordship.
That we can say about him,
About the entry number
but if
46.
deserving candidates are others are deserving, what?
Yes,
How
yes,
can we
yes,
stop?
yes, yes, Lordship, absolutely right.
So you
Lordship.
cannot stall the process.
Yes,
This is
yes,
a
Lordship,
fun
Lordship.
generating thing. Heart. Mr. FZ Majumdar, Learned Counsel for the petitioner. Miss R. Devi, Learned Central Government Counsel for the response number 1. MS R. Bora, Learned Standing Counsel, Agriculture Department for the response number 1, 2,
Lordship,
2,
Three.
1 and 2. Who is the chairman? Who is the chairman in DLEC?
DLEC is the collector. Lordship.
Collector. M. Bormon, Learned Junior Government Advocate Assam for the response number 4. R. Bora likhibo 1, 3 and 5. 5? Oh, 4. Oh, your number is wrong.
Lordship, respondent number 5, I don't have anyone.
Huh?
In my copy, Lordship, respondent number 5, nobody is there.
But the original.
See your number. Number is 4. Turn the leaf.
Yes, yes. It will be 6.
It should be 5 and 6.
1, 2.
Okay,
3.
1.
It will be 6. Last one, the
Oh, sorry, 2, 3 and 5. 2, 3 and 5. Mr. Ojundar, Learned Counsel for the petitioner has submitted that he may be allowed to file an amended cost title in terms of the notification dated so and so in order to correct the names of the party respondent number 5 and the party respondent number 6 respectively, which are mentioned as party respondent number 4 and party respondent number 5 in the cost title, comma within by tomorrow. By tomorrow. Post of capture likhibo. The petitioner is an agricultural service group. Post of. Within bracket SHG within bracket self-help group. Full stop. Where it has been projected that the government of India in the Ministry of Agriculture and Farmers Welfare has launched a mission named Submission on Agricultural Mechanization. The mission for short. Sorry, SMAM. First of, as per the operational guidelines of the SMAM, comma, the submission, sub-mission, sub-mission. The objectives of the submission is to identify the areas of low ratio farm power availability, stroke areas with large number of small and marginal holdings for implementation of farm mechanization components. Full stop. The petitioner has projected that they fulfill the criteria of the submission to be a beneficiary. Full stop. Para. Mr. Mojumdar, Learned Counsel for the petitioner, has submitted that in order to identify the beneficiaries to avail the benefits of the SMAM, comma, the task of identifying the beneficiaries of the SAMAM at the district level is entrusted to the district level executive committee, DLEC, and the DLEC has to carry out the process of identification of beneficiaries in a transparent manner. First of, it is his further submission that the petitioner has submitted an application for what?
For obtaining benefit of.
For obtaining benefits under the SMAM as a beneficiary. Full stop. The petitioner has come to learn that benefit has been extended to the respondent number 5 by the DLEC in the district of Kachar, comma, which is represented by the respondent number 1, Odes Kumar Singh. Full stop. Mr. Mojumdar has drawn attention to the documents annexed as Annexer Z to this writ petition to highlight Annexer Z to highlight that the respondent number 5 had in the assessment year 2009, that's 2010, had submitted an ITR showing income more than 3 crore. And as such, the respondent of 5 could not have been extended the benefit under the SMAM post of. As a result of selection of such kind of beneficiaries like the respondent number 5, the petitioner has been deprived of the benefit under the SMAM post of. MS Bora, Land Extending Council. Agriculture Department has sought some time to obtain the instructions in the matter. Post of. Issue notice returnable on so and so date. As so and so has appeared, accepted notice on so and so, no formal notice. The petitioner shall take steps for service of notice upon the respondent number 5 by registered post with AD. Post of. Having regard to the fact that the submission named SMAM is meant for beneficiaries for areas where farm power availability is low, or for areas with large number of small and marginal holdings. And the respondent of 5 and from the document annexed as Z to the writ petition, it primarily appears that besides the high worth individual he has agricultural and non-agricultural land. How much area he has? He and his family. He and his family have large family members have large chunks of agriculture properties, including agricultural land, non-agricultural land, commercial building, residential building. It is observed that if the benefit under the submission SMAM after his selection is not extended to the petitioner till date, then the same shall be kept in abeyance till the returnable date. Name of the landed government advocate Assam be reflected in the respondent side in the cause list.
Item 18.
May I please, Your Lordship? In this case, my lord, the husband of the petitioner, my lord, died in car, my lord, while he was returning from his workplace towards home, my lord. That means 37, the police report.
37?
Yes, my lord, the police report, my lord.
Yes, Ms. Parman will issue notice at this stage. Heard Mr. W. Rahman, Learned Counsel for the petitioner. Any central government council? MS? MP? MK Sharma, Learned Central Government Council. G. Pegu, he is Central Government Council. Okay, representing so and so for respondent number 1. MSPR Mohanto, Learned Standing Council, Revenue and Disaster Management Department for the respondent number 2. B. Gogoi, Learned Standing Council, Finance Department for the respondent number 3. Ms. M. Bormon, Learned Junior Government Advocate Assam for the respondent number 4 to 7. Post of the petitioner is the wife of one late Suresh Das. Post of it is the case of the petitioner that her husband, Suresh Das, died in an incident of accidental drowning in flood, and his dead body was found floating in a river on 26/6/2023. Post of the petitioner has approached this court by the instant writ petition seeking interlinear direction to the respondent authorities to extend the benefits of gratuitous relief in terms of the gratuitous relief under the State National Disaster Response Fund, NDRF stroke State Disaster Response Fund, SDRF, in terms of a notification dated 27/7/2011.
At least 25, my lord, revised norms, my lord. At least,
Huh?
at least 25.
Of the Government of Assam Revenue and Disaster Management within bracket General Department, Annexer 1. Post of issue notice returnable in 4 weeks as so and so appeared. Formal notice stands dispensed with, extra copy during 2 working days.
Like
19.
Lord, my limited prayer in this case is a direction for disposal of the representation at page 38. Lord, the representation-
38.
Page 38. Lord. The represent. We had submitted this representation on my left hand side on 20th September, my lord, till now. Nothing has been done.
Yes,
My
Mr.
lord, This is a Wakaf board, my lord, no one is there. So
Okay.
only a direction that within a specific time we will furnish the certified copy, let them dispose it the representation.
Now this will be expired then.
So we, my lord, either we are saying that you allow or reject, my lord. Let us know where do we stand, my lord. That is why. Suppose, my lord, the other side appears also. My limited prayer is to that extent.
Okay, you serve him copy by Dusty also. Notice, we can short notice. If you
That can be done, my lord.
can do it, then we can put it on short notice within 15 days. You file a Dusty, at
Yes,
least.
Yes.
Because disposal of a writ petition is without hearing him. That can be after his appearance, we can dispose the writ petition to consider on its merit. Heard Mr. Edas, Learned Counsel for the petitioners. Post of the petitioners have approached this court by this writ petition, agree by non-disposal of their representation submitted before the sole respondent on 29/2024. Post of issue notice returnable on 4/12. Petitioner shall take steps for service of notice upon the sole respondent by registered post with AD by tomorrow. Registered post AD.
Yes, steps.
Post up. As prayed for, the learned counsel for the petition. The petitioner is also permitted to take steps upon the sole respondent by way of dusty, which is to be routed through the registry of this court. Post up. The petitioner, after serving the notice by way of dusty, shall file a compliance affidavit to that effect on or before the returnable date. Place the case on 4/12.
Then it be on 25th, my lord.
25th.
25th, my lord. Monday.
The registry will take some time to
No,
prepare the
because
dusty.
either
We make
let
it
us take a
29
chance.
then 29.
29.
We'll make it 29. Okay, 29.
Yeah.
Item 20.
May it please the lordship. Lordship, the subject matter of this instant application is such, lordship, petitioner's father and uncle possess the plot of land from a one.
Holding tax.
Yes, lordship. There's some,
Hold-
they have been, they were paying the tax and thereafter lordship dispute arose between.
You are saying the railway is also a
Railway-
claimant.
Yes, lordship.
According to you, you
Yes.
have given a chart, page 19.
Page
They are also demanding money from you.
Lordship,
Huh?
Lordship, what is the most heinous thing which has happened? The authorities from. municipal-
Heinous, no,
Yes,
not
Lordship.
in.
Lordship, what has
Ah,
happened?
coercive.
Not only coercive, lordship, they are the executive officer headed by 10 person outside people entering the premises. They are doing the measurement themselves before this 10 days ago, lordship. And they're every day they are issuing threat, lordship. That
You're not paying
complaint-
money also.
I have paid lordship and this is the payment receipt. And meanwhile, I have paid an amount of 75,000. In spite of that, when lordship page DC's endorsement, lordship would be pleased to see page 21, lordship. I have on this condition, lordship, addressing the whole issue that the holding tax in the year 2015, 14,
When did you pay?
October, lordship,
What is the date of payment?
is 25th of October, lordship.
This payment is 25th October.
Yes, lordship. Till, according to them, till now, as per notice dated, lordship, 26, 2024, till now, we have paid this, 14, 15 is cleared, 15, 16 is cleared, 16, 17 is cleared, and 17, 18 is cleared, lordship. Lordship, may kindly see page 20, lordship, how exorbitant increase in the holding tax. That in the year 2014-15 is page 14-15 it was 550, then 15-16 650, then 16-17 jumped to 36, and then 24-25 jumped to 51,000. Addressing the whole issue, the petitioner written.
How much is the area?
Now it was earlier 3,60,000.
No, how much is the area?
Area is 4 katha, lordship.
Hmm?
4 katha of land.
Where have you mentioned?
Yes, I have even in the synopsis also, lordship.
No, in the read petition. Synopsis is not normally to be taken as a part of the read petition. Yes, Mr. Sharma, Lamding. Board. Municipal.
I am not representing the municipal board, Lord.
Hmm.
But one thing is there, Lordship, page 42. Oh, sorry, page 21.
21.
She has stated that she has made a representation before the deputy commissioner paying for payment in installments. On the top right-hand side,
Allow.
may allow,
May allow, may
may
allow.
word is there. That is not a, Lordship. That is there. The district commissioner
to
has raised the
demolish.
matter on upon the
That was
Municipal
on,
board.
that was on which date?
24/6/2024.
Thereafter, they have paid one
Yes, sir.
amount,
We got-
25th October, July, as well as October. Total maybe 75,012. So at least if 1/4 has been paid.
I leave it to Lordship because I am not representing the municipal board.
No, as a whole, I am
Lordship,
seeking your
Lordship,
assistance.
And Lordship.
And
in addition to
as
that-
a assistance as an officer of the
Yes,
court.
Yes.
Because
And in addition to
see
that-
page, whatever is there, page,
Now, even if your Lordship comes to page 20,
that is exorbitant,
Lordship.
increase.
That I admit, sir. That I admit. Sir. That is why I am placing this.
Okay.
652, it goes up 36,906. More than 1,000 times.
Third, Miss T. Shom, Learned Counsel for the petitioner. MS PR Mohanto, Learned Standing Counsel, Revenue and Disaster Management Department for the respondent number 1. Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 2. 2 and 5 perhaps.
Executive officer, I think. Sorry.
Otherwise, he's a
Lordship.
He is a state government official, otherwise
Lordship, I
deputed. Why you are naming him?
Lordship, because of our conduct, Lordship.
Then he cannot accept. He has been named.
In my petition.
No,
the name is
before the
not-
court.
But
Some
their
change.
Lordship, their name is not there. That is why. If by name Lordship, I cannot.
No. First of the petitioner has stated that the father of the petitioner purchased a plot of land from one Narayan Singh, and after such purchase, the petitioner is in occupation. The family of the petitioner is in occupation of said plot of land, wherefrom they are running a fabrication business. First off, the petitioner has further projected that a litigation is going on in connection with the areas, lands in that locality between the respondent municipal board and the railway authorities. First off, it is the case of the petition. Where is the detail? No detail. Land details? The said plot of land is being assessed by the respondent municipal board for holding tax. HOLDING, holding tax, capital. First of all, the petitioner was paying such holding tax as assessed by the respondent municipal board. Holding tax stroke property tax. Bracket of it. First of all, on 26/2024, the petitioner was served a notice by the executive officer, Lamding Municipal Board, stating that the following amount was payable towards holding tax stroke property tax. Table quantity about 2014 or 2024-25. Total to page 20. MS Som, Learned Counsel for the petitioner, by referring to the amounts assessed by the respondent municipal board during the period from 24 2024-2025 to 2024 to 2025-2025 has submitted that there has been exorbitant increase of the rates of holding tax stroke property tax. Full stop. Without prejudice to their other rights, the petitioner had preferred a representation before the respondent number 3 on 24/6/2024 to allow him to pay the amount of rupees 3,62,752 in installments. Full stop. And the respondent number 3 forwarded the said application to the Executive Officer, Lamding Municipal Board, to consider the matter about granting installments. Full stop. But the Executive Officer, Lamding Municipal Board, served another notice on the petition on 5/7/2024, demanding the entire amount of rupees 3,62,752 Where is the installment or anything there? No.
No.
He is also saying about first installment. Huh? Demanding the petitioner to deposit the first installment without mentioning the amount. Full stop. MS Som has submitted that subsequent to 5/7/2000, subsequently, the petitioner had deposited an amount of rupees 38 lakh or 38,106 on 16/7/2024, and a further amount of rupees 36,906 on 25/10/2024, that is, rupees 75,012 in total till date. Post stop. As the petitioner is apprehending demolition of the structures standing on the plot of land in respect of which the petitioner has been paying the holding tax or property tax, the petitioner has approached this court by this writ petition. Issue notice returnable on so-and-so date. As so-and-so appeared accepted, so-and-so, the petitioner shall take steps for service of notice among the respondent number 3, 4, and 5 by registered post with AD within 2 working days. Full stop. Considering the fact that pursuant to the assessment of the amount of rupees 3,62,752 as holding tax stroke property tax by the Executive Officer Lamding Municipal Board on 26/2024, the petitioner has deposited an amount of rupees 75,012. It is observed that till the returnable date, the petitioner, the respondent authorities in the Lamding Municipal Board shall not take any coercive action, including demolition of the structure against the shall not take any coercive action for demolition of the structure standing on the plot of land in respect of which the petitioner has been paying the holding tax stroke property tax.
There shall not be
Oh,
any
stop.
bar.
But
making
returnable on so and so. No, you deposit another one
Installment law.
in the meantime. Then we'll see about exorbitant part. the petitioner returnable kiman dile on or before. But this is exorbitant. Not
Exorbitant
true.
is true, Lord. I also admit.
Well, not
Regarding
direct,
that,
but
installment
it's
payment
a,
also, because there was
pendency of
the
this petition shall not be a bar for the petitioner to deposit further amount towards the holding tax to property tax on or before the returnable date. Right? The name of the learned standing counsel so and so be reflected in the respondent side the cost list.
Item 21.
She may kindly come to annexure 10, my lord, impugned letter, my lord. Annexure 10, page 82, my lord,
Annex 13.
page 82. This is the vernacular type letter, my lord, letter dated.
Annex 13.
Annexure 10, page 82.
82.
82, yes.
80.
82, Lords.
82.
82.
This is the SMS portion. my lord. This is a letter by the circle officer, Saridwar Circle Office, my lord, addressed to additional DC, my lord, Honitpur.
Now at this stage, what do you want?
Notice go, Lords.
Let a notice go.
Petitioners 105 biggest land actually.
Is there any disposal of representation pending?
This is in pursuance to representation only, my lord. Worship will find no
Okay.
pending, no pending.
Heard, Mr. D.K. Bakshi, learned counsel for the petitioner. Petitioners. Piermont of Revenue Disaster 1. H. Sharma, learned additional senior government advocate for the respondent number 2 and 3. Close to. The petitioners, comma, 32 in number, comma, have approached this court, stating that they have a common cause of action. Full stop. You have made it bulky by depositing so much of.
Yes, my lord. All the representations, my lord.
No.
The meeting.
Before that,
Yes, my lord.
by submitting your email, etc.,
Yes, my lord.
you have added 32 pages more.
My lord, I have to speak with my clerk, my lord.
I could not find the beginning of the writ petition.
Yes, my lord, sorry.
The petitioners are seeking new pattas for parcels of land measuring 105 bighas.
Not new pattas, my lord. Already patta allotted to some of the petitioners and some of those were not allotted. Positions were not given, my lord.
And the Saridwar revenue circle, or to release the acquired land. Release the land, comma, acquired for the petitioner, comma, for the establishment of industrial growth center of the respondent number 4, so that the petitioner can be resettled therein, or to pay adequate compensation for such acquisition. Issue notice returnable in so and so, as so and so, the petitioner shall take steps for service of notice upon the respondent number 4 by registered post with AD.
Lordship is making it returnable 4 weeks.
This is a case of Panchayat delimitation case, Lordship.
Delimitation. Mr. Doctor,
My lord, petitioner's personal grievance, my lord, he's a prospective candidate of election, my lord. And some boundaries are altered violating the SOP. This is the,
basic
yes,
latent grievance is that.
that only. I have
He is
prepared a list,
expressing, but others are not expressing.
my lord.
Other people, what to do?
Maybe fix on 20, my lord. Allow it.
20?
Other similar matter fixed on
Other petitions are there.
Yes.
534624.
We put it in the motion column that way. It will be better.
Yes, yes.
We cannot issue notice at
Yes,
this
yes,
stage.
yes.
Okay. MS
A Begum.
A. Begum, a learned counsel for the petition, and Mr. S. Dr. Learned Standing Counsel, Panchayat and Rural Development Department. Our H. Sharma Likhediwa, learned additional senior government advocate have submitted that writ petitions, involving similar issues, are ordered to be listed on 2011-2024, and therefore, this writ petition be also listed on 2011-2024. List this case accordingly on Twitter.
I love you.
Item number 23.
May I please, your Lordship, by this writ petition, the petitioner is praying to, before this honorable court, to direct the responding authority to register an FIR which was filed on 10/5/2024 before the Azra police station. The petitioner filed
Okay, you filed the FIR. Thereafter, what did you do?
the petitioner filed this FIR, but the Azra police station OC is not registered this case.
Okay, then what did you do?
Then he go to the additional director of additional DGP to by a complaint.
Okay,
but
since
additional
May, May, who is advising the petitioner? You.
My lord,
Since May 2024, who is advising the petitioner?
petitioner is
consulting you or not?
yes, my lord.
Yes. Why did not you advise him to approach the superintendent of police?
My lord, he approached the ADGP and
Why your CID?
CID.
Why you are going to somewhere else?
Then
you should have approached the superintendent of police or
referred to the petition to the commissioner of police, my lord.
okay, no action.
Then commissioner of
No
police,
action.
Commissioner of police communicate to the Azra police station, but till now no action has been taken.
Then what do you have advised to your client now? To file a writ petition?
Yes, my lord.
175(3). Yes, still.
156(3).
That is a CRPC. Now it is 173. This it is called Bharatiya Nagorik.
That is why assistance of Mr. Sharma is required. I have not read it.
Lordship, today morning, Lordship, after
Okay.
going through Lordship.
We'll come back at 2 and pass the order.
Lordship.
You approach. Learned. Name is same, no? Chief Judicial Magistrate, Kamrup Metro Guwahati. Under new provision. Law will be same.
Lordship, that affidavit will be required now. I have a Lordship.
You just point me out.
Lordship.
H. Sharma, learned traditional senior government advocate of some quarter.
126.
126. Full stop. The petitioner. In this petition, the petitioner has posited that in respect of an incident. Sorry. Petition had lodged, stated to have lodged, petitioner had lodged a first information report before the officer. officer in charge, Azara Police Station, on 10/5/2024, alleging harassment, alleging causing harassment to him by the accused persons named therein. Full stop. The petitioner has further stated that when the said affair was not registered by the officer in charge, Azara Police Station, he approached the Additional Director General of Police, CID, Assam, by way of a representation dated 21/5/2024. And the said representation was duly received on what date? Duly received under the seal and signature of the said office. Full stop. The petitioner has further stated that the Office of the Additional Director General of Police, CID, Assam, forwarded the said complaint of the petitioner to the Commissioner of Police, Kamrup Metro, Guwahati, vide letter number 1238, dated 21/5/2024. Full stop. But in spite of forwarding, in spite of the fact that the representation was forwarded to the Office of the Commissioner of Police, Kamrup, Metro Guwahati, no action has been taken either on the FIR or on the representation by any of the respondent authorities, full stop. Which such grievance the petitioner has approached this court by the instant writ petition. Full stop. With a seeking inter alia direction to the respondent authorities, more particularly, the respondent number 6, to register the case on the basis of the FIR lodged by the petitioner before him on 10/5/2024, and to make investigation into the case in respect of the alleged irregularities committed by the respondent number 7 to 9, impleaded in this writ petition. First of Lomba to. First of Mr. Sharma, the additional senior government advocate, has submitted that the petitioner has an appropriate remedy under section 156(3) of the erstwhile Code of Criminal Procedure 1973 and stroke or under section
175(3).
175 within bracket 3.
One is 173(4), another one is 175(3).
175.
That is the earlier it was 156(3).
within bracket 3 of the Bharatiya Nagorik Suraksha Sanhita BNSS, 2023. Our CRPC concern.
CRPC, it is 156.3. This affidavit part is not there.
Section 156, subsection 156.3 of section 156 of the erstwhile Code of Criminal Procedure 1973 has provided that any magistrate empowered under section 190 may order an investigation. Full stop. Subsection 3 of section 175 of the BNSS 2023 reads as under quote corrigible. এটা করো 154 156 to লিখো section 156 of the CRPC reaches under তাৰপিছত এইটো লিখি দিব 75 section 175 para at this stage para 6 to লিখিব para 6 এইটো order para 6 লিখিব তাৰপিছত para 7 তাৰপিছত para 8 and the subsection 3 of section 156 CRPC is perimeter to subsection 3 of section 175 of the BNSS 2023, which only difference, which a difference that an application is to be supported by an affidavit under subsection 4 made under subsection 4 of section 173 BNSS 2003, and the jurisdictional magistrate can order an investigation after making an inquiry as he thinks fit and submission made in this regard by the police officer. Post. In view of such availability of such appropriate remedy available to the petitioner under subsection 3 of section 175 BNS as 2023. And in the light of the observations of the Honorable Supreme Court in Sakiri Vasu Supra, Sudhir Bhaskar Rao Tambe Supra, this petition seeking the above direction is not entertained, reserving the liberty to the petitioner to avail the remedy of approaching the jurisdictional magistrate under section 175 within bracket 3 B and SS, 2023, if so advised. While not entertaining the writ petition, this court would like to clarify that this court has not expressed any opinion on merits of the allegations made in the FIR submitted by the petitioner on 10/5/2024 before the officer in charge of the police station. You approach.
Item 24.
May I be before? May I be before? My lord, this petition, my lord, for a limited purpose, I filed, my lord. There was a order passed by the court, it's a customary court, my lord, which was constituted in terms of 1955 Act, my lord. My lord, is with court is under, my lord, Dimas Autonomous Council, my lord. So this court has passed an order, my lord, depriving me my lord, taking away my property, my lord. That has the property.
This is Autonomous Council Court.
Yes, my lord.
Okay, High Court.
The
Now,
only limited prayer is because since there is no appellate provision because the order has been passed by the learned, my lord, Judge Dimasa Autonomous Council Court, which is the highest appellate authority, my lord, admittedly. So I cannot, my lord, even approach the, my lord, civil court, my lord, in view of the fact that civil court cannot be seen as in appeal, my lord. So limited purpose, my lord, I file, my lord, that this order, my lord, has been put to challenge. And secondly, my lord, this court, admittedly, my lord, in view of the rules. Yes, my lord.
Section 3. An order passed by an appeal.
Yes, this is there, my lord, but
If this is there, then what is this?
my lord doesn't mean that, my lord. Alternatively, my lord, this my main issue is, my lord, the court below has no absolute power, my lord, to deal with the issue. That is why question I wrote.
No, when an appellate, Mr. Muri, and there are other regulations also that will be in the all these sets of books. What do you call? What is that? There are many volumes. Assam by Advocate Mr. Sharma, Advocate V.K. Chopra, or you'll get that appeal from an autonomous council. There is a regulation, right, of 1955 perhaps, or 56, then appeal from an autonomous council court lies before the High Court as per this order, and appeal is to be heard by division bench. Like that, it is there. You first read the provision. When an appeal or judgment is appealable,
my lord,
the appellate court can go into all the questions.
correct.
And there are hardly many appeals. So many do not know the provision.
Respectfully, I agree, my lord. My lord, thing is, my lord, kindly bear me, my lord. I am not even a party to the suit. How can I make an appeal, my lord? And the court erroneously passed.
Yes, Mr. Muri. When there is an appeal, please answer the basic fundamental question.
Yes.
Where a judgment is rendered by a court constituted.
Yes.
Under what? 1955?
Yes, yes.
54 order.
Yes, correct.
And this High Court has made rules that an appeal from that court will lie before the High Court. The fundamental question to entertain this.
Yes.
Have you understood my
Correct,
query?
correct, my lord. I got it. my lord.
When an appeal lies, how can a writ petition to be entertained? That is what I am questioning. After crossing that stage, the court can go into that you are not a party, all these things.
Even my lord, this court may exercise 227, my lord.
No, this is otherwise barred.
My lord, this court may also.
Then I'll hold now, right now, then will not
Otherwise-
say anything.
Otherwise, my lord, notice may.
Will
go, my
not,
lord, at
I'll
this
not,
stage.
I am not reached the satisfaction to issue notice. Heard Mr. N.K. Mori. Learned counsel for the petition. Any standing counsel? Who is standing counsel? Dimahasa? Yes. What is your submission?
So the dispute is between the private respondent.
Yes, Mr. Najari. The petitioner is challenging a judgment passed by the Dimahasa Autonomous Council Court. Right? Rightly or wrongly, whatever has been delivered. A judgment of a principal autonomous council court. That is a three-tier structure. Division bench, in a judgment authored by me, I have all relegated them to the appellate provision there. As per High Court order, an appeal against the final order or decision of the District Council Court in a civil suit, this is a civil suit, shall lie to the High Court. When an appeal lies, whether writ petition is to be entertained.
My lord, once the power has been exercised arbitrarily, apparently, my lord. That's what
Oh,
I
Mr.
think.
Mori,
54 rule is there, my lord.
54, yes,
54.
54. And plus in the regulation, it is to be entertained by division bench perhaps. Assam VK Supra. Okay, I'll put it tomorrow.
My lord, tomorrow, my lord, I'll be having problem, my lord.
Then okay, we'll
Out of
decide
session,
this
my lord.
today. I'll decide this today.
My lord, I'll go through some, my lord.
What? What?
I'll also go through some, my lord, if accommodate sometime.
This is a civil court. Anyway, for civil court, no writ petition. If also civil court, no writ petition. If appellate provision is not there,
If
to
it-
27.
Ability provision, my lord, I'll just take.
Then why I am not undertaking the research? 54 rules and thereafter some regulations also by the High Court that who will hear this kind of appeal. And I think in the High Court rules, he'll appeal is there, Mr. Das? What do you mean by he'll appeal? Heard Mr. N.K. Mori, learned counsel for the petitioner, and Miss
TG.
B.
TG.
B. Jain, learned standing counsel.
Here on behalf of Mr. R.N. Das.
R.M.
Das.
Das. Learned representing Mr. R.M. Das, learned standing counsel, Dimahasa Autonomous Council, post of this writ petition under Article 226 of the Constitution of India is preferred against a judgment dated
My lord. Yeah. 13/2/2024.
13/2/2024, passed by the learned judge of the Dimahasa Autonomous Council Court at Haflong. Full stop. Para. Order 3 of the Assam High Court within bracket jurisdiction of our district council's courts, bracket close, order 1954 has provided that an appeal has entirely provided that an appeal against a final order or decision of the district council court, D capital C capital C capital, in a civil suit shall lie to the High Court for some in view of such appellate provision, availability full stop. At this stage, Mr. Muri, learned counsel for the petitioner, has sought listing of the case on another date in order to complete his instructions. List the case accordingly on Swens.
After a week, madam. After a week.
25.
Applies, madam.
Item number 25.
Disaster.
Wait, please, Your Lordship. In this case, my lord.
Case
the wife
258
of-
also, 258.
My lord, in this case, the wife of the petitioner, my lord, died in fire, my lord. And as such, the under this same notification, my lord, FPS 11, my lord. The police report, Your Lordship, will find at page 38, my lord.
Page 38.
Yes, my lord.
Hmm.
May I read, my lord?
Yes, sir.
My lord.
Disaster. What is disaster?
Yes, my lord. Disaster management section 2D, my lord. Here the definition of disaster is defined, my lord. Due to natural calamity and man-made causes, my lord. There. Section 2D, my lord.
And what is preceded?
My lord.
What precedes man-made causes?
Yes, my lord. Man-made
Huh.
due to negligence, my lord. It is a mishap, my lord. It is a mishap, my lord. And disaster here means, my lord, a catastrophe, mishap, calamity, or grave.
You get it clarified from the, I have already hold. We don't think. At least in my estimation, it is not disaster to be covered under Disaster Management Act.
My lord, my lord, in the notification, my lord, itself in the page 11, my lord, fire is there, my lord. In the last paragraph, my lord.
I have already interpreted.
My lord.
I have already interpreted. Somebody dying in a kitchen is not disaster.
My lord,
In his own house.
my lord, due to negligence, here the definition is that.
Okay, we'll decide at the motion stage itself from
My
the
lord.
police report.
My lord, notice may go, my lord.
No. State machinery is not required to be moved like this. Hard. Mr. W. Roman, learned counsel for the petitioner. Yes. Somebody dying in a kitchen, state is responsible. Either absolute liability or strict liability. It is not a tortious liability. A central government, K. Pukon, learned central government counsel for the response number 1, G. Hazurika. Last Pending Council Revenue and Disaster Management Department for response number 2, any finance. H. Olia, Learned Standing Council Finance Department for response number 3. Ms. S. Kumar, Learned
Government advocate.
Government Advocate for the response, Assam for the response number 4 and 5. Full stop. The petitioner is wife or husband. Husband. Wife.
What died, my lord?
Wife.
What-
Oh, your husband?
Yes, my lord.
Husband of one late Sokina Khatun, Sokina, Khatun, Khatun. First of the case of the petitioner, which no, the petitioner has projected his case in this writ petition on the basis of a police report submitted by the in charge Zoleswar Police Outpost, Police Station, Lakhipur District, Gwalpara, on 19/8/2024, as which is annexed as Annexer 4 to this writ petition. First of para from the said police report, in the said police report, it has been reported that at about 5 p.m. on 26/4/2023, fire broke out suddenly in the kitchen roof of the house of the petitioner, and where Sokina Khatun was making food for the family. Post up. In the fire, Sokina Khatun sustained burn injuries and she died out, and she succumbed to the burn injuries so sustained. Post up. In the process, the kitchen was completely burned into ashes. Post up. In connection with the said incident, an information was received at Joleswar Police Outpost, and the said information was registered as General Diary and Joleswar Police Outpost General Diary entry number 399 dated 26/4/2023. Post up. The matter was investigated into by visiting the place of occurrence. Post up. The inquest proceeding was performed on the dead body of the deceased, and thereafter, the dead body of Sokina Khatun was sent to the civil hospital at Gwalpara for performing postmortem examination. Post up. The postmortem examination on the dead body of the deceased was performed at the civil hospital Gwalpara. Post up. The IO, in the police report, it was further reported that the FIR lodged at Lakhipur Police Station has been registered by Lakhipur Police Station EUD case number 07/2023. Post up. Subpara. In the postmortem examination report performed at the civil hospital Gwalpara, the autopsy doctor has reported that the death was due to shock as a result of epidermal antemortem burn injury sustained over 99% of the body surface area. Post up. Which such projection, the petitioner has preferred this writ petition under Article 226 of the Constitution of India, seeking inter alia direction to provide gratuitous relief to the family of the petitioner in terms of a notification dated 27/7/2011 of the Revenue and Disaster Management Department, Government of Assam. Full stop. The said notification has laid down guidelines for constitution and administration of State Disaster Response Fund, SDRF. Para. the petitioner has contended that gratuitous relief in the form of ex gratia has been provided for a deceased person, and the quantum of such ex gratia has been fixed at rupees 4 lakh. Full stop. Para 3, para 4, para 5. Now I'm holding it is not maintainable.
My lord, sections 2D, my
You have
lord,
the
which
remedy
really
of
says, my lord.
you have the remedy of retable. Let my observation be reversed.
26.
Yes, Mr. Sharma, why you are not making state a party?
Because Lordship.
Commissioner of Police cannot represent the state.
That was so.
A writ petition without the state is not a writ petition under 226.
Exactly, Lordship.
But knowing fully well you have made a party. State not a party. Yeah, that is why I miss. Amend the writ petition so that make him a party.
Yes. Can it be
You submit an amended cost title.
cost title?
Better.
Yeah. Lordship can the matter
Because states and its instrumentalities. He is an instrumentality, state is not there. Mr. Sharma, counsel for the petition has submitted that he may be allowed to file an amended cost title in terms of the notification that it's so and so. The prayer is allowed, lays the case. The such amended cost title is to be filed within 3 working days from today. Office to list the case after submission of the after receipt of the amended cost title and making necessary correction in the cost title of the writ petition as per the amended cost title, necessary correction in the cost title of the writ petition, making necessary correction. Immediately thereafter will do as a motion.
27.
Yes, GST.
Lordship, the petitioner registered dealer under the.
Cancellation.
Yeah, Lordship.
Simple thing is cancellation. What to do?
My Lordship owns as well.
Huh?
64 pages. No?
Is it there?
In actually 37 page number, Lordship.
Beautifully when elaborated, Your Lordship.
Okay. Is it correct?
Rule 34.
I don't know it is correct or not.
Because there is an alternative made. Rule
Huh.
is there here. In
Huh?
GST. Rule is there.
Rule is there.
And you have been elaborated, Your Lordship. So,
Okay, give a copy of these orders to both of them, make the necessary correction at the proper place. Then we'll see.
Lordship.
If I'm satisfied, then I'll pass the order. Or otherwise, I'll put it on Monday.
Lordship.
Right?
Lordship.
You give a copy of the order. That annexer page.
Page
37.
37, annexary.
Give a copy. Both of them will correct at the necessary place. Then I'll look at, then I'll pass.
Monday?
No, I'll dispose of today itself if it is corrected by pencil or pen at the necessary place. Right?
My name may be reflected, Your Lordship.
And if I'm not satisfied, I'll get it listed on Monday.
That's why my name may be reflected, Your Lordship. Otherwise,
Okay, okay, Dr. BN Gogoi,
I'm deeply obliged.
Obliged, Lords.
Item 28.
Yes. Mr. Rava,
Yes, ma'am.
you have carried out the process and stopped at a particular point of time. One kata, two lesser demark,
Yes.
right? And for remaining three lessers, she'll file civil suit for restoration of possession if it is encroachment.
Yes.
There is no other remedy. See the report. Where is the report? Where is the report, madam?
It is in.
Circle officer?
25, Lordship.
25. See, Mr. Rava,
Yes, ma'am.
26. C made a demarcation application, he, Binoy Kumar Nath. Then you carried out the demarcation process. C claimed that he is the owner of one katha, 15 lesser. And Mondal and revenue officer, they found after measurement that the petitioner is in possession of one katha, 12 lesser. Complete that part, then he will avail appropriate remedy. He is saying somewhere. Yes, come to page 28. See page 28.
Yes, ma'am.
Read
So that,
yourself.
well, I'm a retired person having a landed property at Dupirtal, Pakiragram, under Dotma Revenue Circle, Koprazar district. And I had applied for demarcation of my plot of land before the circle office Dotma. The whole demarcation process was started, and Lad Mandal measured my plot and found that around 3 lessers of my land was encroached by someone else. Yet the circle officer did not complete the process of demarcation.
He has correctly said. Then, as a result,
I am not in a position to understand from which direction the side 3 lessers of my land is encroached. You are requested to direct the circle officer to complete the process of demarcation at the earliest, so that
is what he needs.
Hello.
You have measured everything, north, south, east, west, found that he is in possession of one katha, 3 lesser, 12 lesser. You complete the demarcation process. About 3 lesser, petitioner will take appropriate steps.
Yes, sir.
He has to know whether Mr. X in the southern side or Mr. Y in the northern side has encroached upon his land.
Yes.
Make the demarcation.
I'll obtain an instruction.
No, what? A direct. What do you say? Within a period of
Yes, ma'am.
6 weeks or 8 weeks, whatever you want.
Yes, ma'am.
Hard. Miss
Arsha.
R. Sharma Shah, learned counsel for the petition. And Mr. S.R. Rava, learned standing counsel. BTC. For all the respondents?
1, 2, 3.
5, 6. Yes, madam, what do you say? MS so-and-so, learned government counsel for the respondent number 4. Please, your name please, Anna. Stop. In view of the limited prayer made by the petitioner in this petition, and as agreed to by the learned counsel for the parties. This writ petition is taken up for final consideration and the motion stays itself. Full stop. The petitioner has claimed that he is the owner of a plot of land. Madam, how much is your land? You don't take care of your own writ petition. We go by your statements, paragraph 2. See your paragraph 2.
Land measuring 15 letters.
And 1 katha means what, madam? One katha means what? You know the measurement of katha, lesa, bigha?
5 katha is 1 letter.
Huh?
5 katha was 1 letter. 5 katha means 1 bigha.
How can we, from the averment, we have to dispose the writ petition? If you don't take care, sorry, madam, we cannot do with this kind of. We thought to dispose of your writ petition, giving you the relief. I cannot make this correction on the prayer of son. You better correct that this cannot be corrected now. I think 20 lesa is 1 katha.
Yes.
Means that 1 katha plus 15 lesa means 35 lesa. On measurement, it is 32 lesa. All these are not there. You have said that you are owner of 15 lesa. Then you are much in possession than 15 lesa. You are in possession of 1 katha 12 lesa. You file properly. Madam, we thought that we will dispose of this writ petition, giving you the relief. Next case. This kind of mess in a writ petition. In paragraph 2 of the writ petition, the petitioner has stated that he is the owner of a plot of land measuring 12 or 15 lesses. And the relief claimed in this writ petition is that in the application for demarcation, the revenue staff found that the petitioner is in possession of 1 katha 12 lesses. Full stop. In the prayer. In the application submitted by the petitioner before the District Commissioner Kokrajhar on 10/1/2024, the petitioner, without mentioning the area of land in respect of which he claims to be an owner, has only mentioned that on measurement, an area of land measuring 3 lessers was found to be lesser. So in such way of the matter, learned counsel for the petitioner has sought time to complete her instructions. This is the case after it.
Item number 29.
Yes.
Before one of my friends starts, that they have already filed an writ petition without liberty, they have withdrawn it. Now a second petition.
Lordship, at para 16, I have
Sarguja Transport.
mentioned at para 16
Without
of
liberty.
petition. The petitioner has filed a writ petition before this honorable court relating to the subject matter, which is numbered and that same has been withdrawn due to some inadvertent mistake, Lordship.
Madam, where is the liberty? Where is the liberty? Sarguja Transport. Oh, Sarguja Transport. Same prayer. Parties ditto.
That land, that paragraph is.
Parties are same.
Same thing.
Lordship, may I?
Even I have the petition also.
Lordship,
No, we'll not do that.
Lordship,
You distinguish it hard, Miss T. Shom, from Miss Lalu. Learned Counsel for the petitioner. Miss G. Hazarika, Learned Standing Counsel. Revenue Department for the respondent number 1 and 2. Miss S. Kumar, Learned Junior Government Advocate for the respondent number 3. And Mr. S. Bora, Learned Standing Counsel GMD for the respondent number 4.
I may be allowed to, Lordship, the new cause of action that pertaining to a separate representation, Lordship. That representation.
Oh, so representation does not give rise to any cause of action.
That my learned
Representation does not give rise to any cause of action.
that is regarding to that mistake was there. That is why that for the mistake.
You are a seasoned counsel. You are a seasoned counsel. What is your prayer otherwise?
Lordship, my prayer is that, Lordship,
Settlement.
Lordship, the
Writ petition is not maintainable now. There are other appropriate remedies. Heard in this writ petition is preferred by the petition on the with the projection that he is in possession of a plot of land measuring 13 quarters covered by dark number 85 and pattern number 22, situated at Revenue Village, Satgaon, Moja, Beltala, Dispur Revenue Circle, District Kamrup, Metro. Since long. Postum. In an eviction process carried out on 28/2/2023, the petitioner was evicted from the said plot of land. Postum. The petitioner has stated that against such allegedly illegal eviction, the petitioner submitted a representation before the respondent number 4. For consideration of the prayers made therein. Mr. Boral and its standing counsel GMD appearing for the respondent number 4 has submitted that the writ petition the petition has approached this writ petition for the second occasion after preferring a writ petition, WPC number 2819/2024. It is submitted by him that the said writ petition WPC number 2819/2024 was withdrawn on the prayer of the petitioner and by an order dated 27/9/2024 without any liberty to file a fresh one. It is submitted by him that the extended petition is not maintainable in law. 2009 content? 9, no? The What kind of land it was?
Lordship.
Government khas land.
Yes, Lordship,
Huh?
but our petitioner's boundary does not fall within the restricted zone, Lordship.
Hmm?
So, Lordship, even actionia patta was issued in favor of the petitioner, Lordship. Before carrying out the eviction drive, Lordship, the respondent not even enlisted the.
Are you in possession of Pata land?
Actionia.
Do you have any? Huh?
No other land now, Lordship.
No,
Now
no.
become landless.
These lands are what kind of land?
These are the caste lands, Lordship.
Khas land.
And for last 100 years, they are in occupation of the said land from their forefathers, Lordship. They are the indigenous people, Lordship. And without prior notice, they have been evicted, Lordship.
Hilhaku area.
Yes, Lordship. But that doesn't come, petitioner's boundary doesn't come within the four corners of the restricted zone. I have mentioned that at para 5 of my application, Lordship. Even for settlement, there was some negotiation and they have been assured verbally that there will be settlement in their favor. But midst of that, Lordship, they carried out the eviction drive.
The Lordship, can't you see the paragraph number 2? Here, my lord, he says this is the government land, but he gives the tag number also, pattern number also.
That is also confusing one.
Actionia patta.
Now, madam, come to your representation.
Yes, Lordship.
Following are the details of the land owned by my family.
Are the family members also included, Lord?
No, we are not deciding. You are saying that Pilani Lalung.
He is my grandmother.
This is that petitioner is a grandson of late Pilani Lalung,
Yes.
right?
Yes, Lordship.
Now you are in possession of Pilani Lalung land.
Yes.
Huh?
But so far myself concerned, I was in position of 13 kata, Lordship. Not all.
Yes. Now, where is your mention of that diagram number 85 in your representation? Page 18 or your translated version 17. As no liberty was sought for while withdrawing the previous writ petition, WBC number 2819/2024, on 27/9/2024, and no liberty was granted, this writ petition preferred for the second occasion by the petitioner is found to be not maintainable, and accordingly, the same stands dismissed.
Lordship, however, one observation, Lordship, for ends of justice,
Dismissal of the writ petition. Would not constitute that the petitioner would be precluded from seeking appropriate remedy available to him under the law.
I'm deeply obliged.
Yes, Mr. Chauhan.
By amount of maintenance, my lord, CGM directed to deduct.
Any State Bank Council?
State Bank, my lord.
Huh?
State Bank.
State Bank Standing Council is there. Who is he?
Shown in the quote list of them.
Who is it? On whom you have served? How
My lord,
Notice
but not the quote list, it is shown, my lord.
Notice con. কার serve করেছে? BK Sen. BK Sen. And if BK Sen is standing counsel, then will reflect his name. Other we can fast track, Mr. Chauhan, about your money. If he
It is in the quote list, standing council reflected.
his name is
Not there, but standing council SBI.
right. If he is present today, I can fast track your redressal of your grievance regarding non-release of money to you by the State Bank. Are you sure, madam? BK Sen is a standing counsel. Okay. Mr. Sohan, S. Sohan, counsel for the petitioner is present. Learned standing counsel, Mr. BK Sen, learned standing counsel, SBI, is found absent today on call. Full stop. Having regard to the nature of grievances raised in the state petition, let the case be listed again on Wednesday. Wednesday. The name of Mr. BK Sen, standing counsel, SBI, be reflected in the respondent side the cause list. We can dispose of at a motion stage itself. Agree by non-selection.
My lord.
Heard. Yes, Mr. Das. Well, you should know this. Heard. Or anything to be submit.
Sorry, Miller.
Anything to submit.
They have basically alleged malafide against the selection committee,
Is
but
it?
the members are not parties.
Oh. Then I have to see the pleading against 6, 7, and 8.
Yes, there is nothing in the petition. my lord.
Then I'll impose cost.
Then selection committee minutes also not annexed, my lord. Some haste is there.
My lord, here basically, my lord, the petition hearing, my lord, is the senior.
No, it has become a fashion or what? It has become a fashion.
Para 8, my lord, will see pick and choose manner selection committee adopted.
Okay, this can be done, but making them by name as parties, has it become a fashion? Nowadays, I have seen now. Chief Executive Officer, Deputy Commissioner, name by parties,
No, my lord, here.
when they are discharging official duties.
That should not be.
Huh?
That should not be.
My lord, here, my lord.
They have visited for measurement, make him party by name. It has become a fashion. Now consequently also cost should be also imposed in an appropriate case.
Yes.
Let us see the allegation of malafide, how it has done. It is very too easy, allege malafide.
My lord. Here, my lord, basically, my lord. In this
No,
case,
not basically. 6, 7, and 8.
in this case, my lord, petitioner.
6, 7, and 8.
My lord.
Where is the specific statement?
My lord, 6, 7, 8, my lord, those are the junior than the petitioner, my lord. Those are the junior to the petitioner, my lord. My lord, kindly.
Or these are selected candidates.
My lord, yes, my lord. That is why, my lord, they are.
What you have said, Mr.
What said that his contention in the petition to challenge the selection is that the selection committee adopted pick and choose manner and all those things.
Okay, let us
So
check
that
it.
is- That is.
At least the person has a right. Heard Mr. S. Hawk, learned counsel for the petitioner, and Mr. H.K. Das, learned standing counsel. I thought that they are selection body members.
No, my lord. But why I am saying so that if you are alleging mala fide, that's the selection committee has to be. That's
No, this comes when you're drafting a
yes.
petition
yes.
with a copy paste. You are representing whom?
I'm 1 to 5, my lord.
Standing counsel, ZHC, for the response number 1 to 5. Full stop. Alleging, agreed by his non-selection
Page 18, madam.
to the post of LDA
LDA, my lord, and
and vacant post of LDA and 2 posts of copyist
copy.
in the establishment of the response number 5
My lord.
in a selection process undertaken. The petitioner has approached this court by the instant repetition. Full stop. Issue notice returnable on so and so date. As Mr. Das 1 to 5, the petitioner shall take steps for service of notice upon the response number 6, 7, and 8 by registered post with AD within 2 working days. Extra copy. Extra copy.
Obliged, madam. Much. May I please, Your Lordship? Lordship, this matter is already covered, Your Lordship. Similar judgment is it?
Yes, Mr. Gogoi.
83.
Dr. Gogoi? Oh, B. Gogoi is there. Okay.
Covered to the extent that, my lord, here they have made 3 prayers. Lordship may see the prayer.
Prayer.
Yeah, page 47.
Notification extending the period of limitation. 6/9/2024.
Lordship will find that at page 82. Now, this is the, my lord, notification which has been issued by following the notification 9 of 23 of the, my lord, CGS of the central government, which has been upheld by the, my lord, by court movements in a series of cases.
Okay.
So that challenge will not sustain.
So, meaning thereby that there was recommendation of the GST Council.
Yes, there was the last one, my lord, having the recommendation.
And what about the third prayer?
But it is same, my lord.
This is based on what? Summary or? I think the case is on summary, I think.
Yes,
So
yes,
cause notice.
Yes, Your Lordship.
Your case is based on summary so cause notice without there being a so cause notice under section 73(1).
Yes, only, my lord, remain is prayer number 3. Let it be on Friday, my lord, on that point.
Friday or next Friday.
Next Friday, not this Friday.
Next
Along
Friday.
with the-
Okay, let him take instruction.
Yes, sir.
Heard Mr.
SK Saha. Your Lordship.
S.K. Saha,
Yes.
learned counsel for the petitioner, and Mr. Dr. Gogoi, you are there?
1 and 2 years.
Dr. B.N. Gogoi, learned as a central government counsel or CGST?
Central.
Central government counsel for the response number 1 and 2, and Mr. B. Gogoi, learned standing counsel.
3, 4, and 5.
Finance and Taxation Department for the response number 3, 4, and 5. Full stop. The case of the petitioner is that without issuance of a show cause notice under subsection 1 of section 73 of the SGST Act 2017, the respondent authorities had proceeded on the basis of a summary of show cause notice under Rule 142(1) small a of the corresponding rules. Full stop. It is the case of the petitioner that without issuance of a notice under subsection 1 of section 73 of the SGST Act 2017, a proceeding initiated on the basis of such summary of so cause notice is not pensionable, and the case of the petitioner is covered by judgment or decisions of this court. Full stop. Mr. Gogoi, learned standing counsel, Finance and Taxation Department, Assam, has submitted that the case be posted on Friday next. So, in order to complete his instructions. Full stop. Mr. Gogoi has submitted that So far as the prayer A and prayer B made in this writ petition is not sustainable because of orders passed in other writ petitions. I'm making it limited to prayer C.
Item 33.
Yes, Mr. Chauhan.
30, my lord. Instead of 20, my lord, can it be 22, my lord? I have.
Date. Okay,
Yes.
22.
22. Item number 33.
May please, Lordship. This is regarding, my lord, settlement of land, my lord. The SDLC, my lord, subdivision land advisory board, my lord, held a meeting, my lord, and recommended.
Will issue notice at this stage?
My lord.
Will issue notice? Yes. Heard. Mr. H.R. Ahmed, learned counsel for the petitioners. Ms. Z. Hazarika, learned standing counsel, revenue and disaster 1. S.R. Rava, learned standing counsel, BTC. For the response number?
2, 3, 4, 6.
5?
I will register post, my lord.
Registered? Okay. 5. Agree by non-consideration of the petition proposal of the land
Advisory board, my lord.
Land Advisory Board for settlement of land in favor of the petitioner by the respondent authorities. The petitioners have approached this court by the instant writ petition. Issue notice returnable in 4 weeks. As so and so, so and so. Extra copies 2 working days. The petitioner shall take steps for service of notice upon the response number 5 by registered posted AD within 2 working days from today.
Congratulations. Production list, item number 1.
May please, your lordship.
Yes, tell me your Patta land.
Yes, your lordship.
Show me your Patta land.
If your lordship comes to Annexure 1.
Annexure 1, page
21, your lordship.
Lordship,
Huh?
let the matter be taken up after 5 minutes, Lord. Let me get the instructions because I can get the instructions just now. After 5 minutes, Lord.
Standing letter, item number 27.
হৈ গ'ল কাৰেকশ্যন কৰি দিছে মই চাম পিছত চাই পেলাই চাম ডিছপ'জ নকৰিব মই ভিতৰত চাই ল'ম ঠিক আছে নালাগে এতিয়া মাতিব হৈ গ'ল এইটো যদি নোৱাৰ ছেটিছফাই নহওক মানডে কৰি দিম
For increasement of party, item 34.
এইটো ভিতৰত দি দিয়ক কাৰেকশ্যন কৰিবলৈ পাৰে বুজিছেনে আগবাঢ়ি থাকিব নহ'লে
May I please, your lordship, my lord?
Yes.
My lord, I have preferred 2 IAs, my lord, for implement of the petitioner, my lord, since the petitioner is no more, and the private respondent number 4, my lord, is also no more, my lord. In IA number 3407, my lord, I have impleted all the petitioners, legal heads of the
IA 3407
407.
petition file to division.
And for respondent 4.
Yes.
And for respondent 4.
What do you say?
Lordship,
Is he alive or is he dead?
not that.
Dead.
Both, my lord. Both the petitioner as the
Notice be issued at the same time because we do not have any kind of contact with the legal heirs of the respondent of 4.
My lord, I have received the list, my lord, since on earlier occasion, my lord, also, my lord, according to his instruction, my lord, he said the.
Let your substitution be allowed.
My lord.
He is not accepting now. That's
He has instructed, my lord, on last occasion also, my lord. That
what is your substitute petition or substitution petition? Which one?
3407, my lord.
3407.
Yes, my lord.
Yes, Mr. Talukdar, what do you say? What is the prayer in the main petition?
My lord, the earlier order, my lord, passed by the, my lord, Land Revenue Board, my lord, cancelling my mutation order, my lord. That was ex parte, my lord, without issuing notice to us, my lord. So set aside that particular.
Okay.
Yes, my lord.
What is your synopsis?
Synopsis is the very first page, my lord.
Okay. What do you say about substitution? Original petitioner Abdul Khalek Khan expired.
Yes.
Mr. Taludar, when did he expire?
He expired in the month of, my lord, August 2021, my lord, actually.
You are doing what?
My lord, I did not receive any instruction, my lord. In the meantime, even the case was also not listed, my lord. There was a gap, my lord.
No, that is, the case is not listed, is different thing.
I understand, my lord.
What is your explanation?
My lord, para 2 of my my lord, I have explained. Page number 5, my lord, 3407. There was a communication gap, my lord.
You are the counsel or who?
I am the counsel for the petitioner, my lord.
Who is this? 8 and 9?
8 and 9, my lord. 8 is the own brother.
How
of
they would come?
My lord, it is specifically mentioned in the writ petition, my lord, that the land was sold to them, my lord. 8 is the, my lord, own brother of the, my lord, petitioner, and 9 is the nephew of the, my lord, earlier petitioner, my lord. I had stated, my lord, in my writ petition, my lord.
Which paragraph you said? Because in the guise of substitution, I cannot add more parties other than legal heirs.
Yes, my lord.
Otherwise, they are not legal heirs in the
My lord.
presence of wife,
My lord.
sons and daughters.
Yes, my lord. My lord, para 2 of my writ petition, my lord, page 3, lordship will kindly see, my lord.
Para 2.
Yes, my lord.
Which line?
Yes, my lord. From the top, my lord. Eleven and 12, my lord. Since then, my lord. Right from since then.
Heard. Mr.
Zaid Hamad.
Zaid Hamad, learned counsel for the applicants. Mr. B.J. Taludar, learned senior counsel, assisted by Mr. A. Chetri, learned counsel for the opposite party number 1, 2 and 3, PR Mohanto, revenue and register. Opposite party number 1. Was also had Mr.
S.A. Bhatia.
S.A. Bhatia, learned counsel who used to represent the respondent number 4. Full stop. In the connected, in the accompanying writ petition WPC number 3355/2020. Full stop. The applicants herein have stated that, sorry, not like the original writ petitioner in the accompanying writ petition WPC number 3355/2020 had preferred the accompanying writ petition assailing an order dated 11/8/2018, passed ex parte, by the Assam Board of Revenue in case number 88 RA within bracket Mori stroke 2017, whereby a mutation order dated 21/3/1995 passed by the circle officer, Puragaon Revenue Circle, passed in favor of the petitioner, has been cancelled. Full stop. In the writ petition, the original writ petitioner has averred that after the mutation order dated 21/3/1995,
Yes, ma'am.
Part of the land was sold by him, sold by the original petitioner to his own brother, Muhammad Abdul Rahman,
Yes.
and his nephew, Muhammad Ziarul Haq in the year 2010. Full stop. Para. The applicant number 1 herein is the wife of late original petitioner, late Muhammad, I think after late Muhammad is not required.
Lord, it is written.
Late Abdul Khalik Khan, Ilyas Abdul Khalik, was the wife of late Abdul Khalik Khan, Ilyas Abdul Khan, the original writ petitioner. And the applicant number 234 were the sons of the original writ petitioner. Full stop. The applicant number 5 is the daughter. Applicant number 5 and applicant number 6
As well as
and
7.
7 were the daughters of the original writ petitioner. Full stop. Applicant number 1 was the own brother, was an own brother of the original writ petitioner, whereas the applicant number 9 was a nephew of the original petitioner. Full stop. The applicants have approached this court by preferring this interlocutory application, seeking substitution of their names in place of the original writ petitioner, late Abdul Khalik Khan, alias Abdul Khalik Khan, on the premise that. Yes, sir. Where is your death certificate?
Death certificate, my lord, is not there, my lord. I may produce, my lord, thereafter. I may be allowed to produce, my lord. It is not there, my lord. It is no more.
How can you, if your son and daughter, how?
My lord, I asked for the death certificate, my lord. They said that the death certificate is not available right now, my lord. But after
Why not available?
After getting confirmation from them, my lord, all of them had put their signature in the Vakalapnama, my lord. Then I filed this, my lord, I am, my lord.
They made the proper verification.
Death certificate is a must. Mister, you are making a mention as an urgent case in the morning.
Yes, ma'am.
Now, without this kind of environment. My original representative died in the month of August 2021. Full stop. A query made by this court to Mr. So Hamad Land Counsel for the applicants as regards availability of not annexing a copy of the death certificate of late Abdul so and so. He has sought time to bring the death certificate on record by filing an additional affidavit. The prayer is allowed. Is the case after one. Bring it on record.
If it is available, I'll definitely produce it.
It must be available.
Deeply available.
You cannot get the benefit of mutation also without the death certificate.
Produce it. Production list, I don't know one.
Yes.
Lordship, Annexure 1, page 21.
Annexure 1,
Page
page
21.
21.
It
Yes.
is no objection
Now,
certificate.
let me see who are the petitioners here.
And the petitioner is on Samia Khatun, Your Lordship.
Samia Khatun. Okay.
In page 21, Your Lordship, this is the no objection certificate issued by the Deputy Commissioner, respondent number 2, as regards the transfer of land from Tahira Khatun to the petitioner, Your Lordship.
Oh, you are the purchaser.
I am the purchaser, Your Lordship.
What is the plot of land?
7 less of land, Your Lordship.
7 lesser.
0.94 R.
0.94 R.
Annexure 2, page 22, it is the permission obtained from the ZMDA, Your Lordship.
Yes.
Subsequently, in page 23, Annexure 3 starts, it is the registered sale deed, Your Lordship. So on the basis of this sale deed executed on 11th of May 2010, the petitioner purchased the scheduled land from her predecessor, Tahira Khatun, Your Lordship. After purchasing the said land, the Annexure 4, page 33, the type copy, the Jama Bandi.
So come to page 30 then.
30, Your Lordship.
This west side is the problem.
West side, it is the
Huh?
PWD road is in the west side, Your Lordship.
Okay.
There is the
That is the problem.
that is the
Bone of contention.
yes, road contention is on the western side, Your Lordship.
Okay.
Your Lordship, if Your Lordship comes to the Jama Bandi, Your Lordship.
So your name is mutated.
Yes, my name is duly mutated, Your Lordship, and I am in possession of it. Thereafter, I have also obtained permission from the GMC and GMDA
Yes.
under Mukhyamantri Sahaj Griha Nirman Asani, and thereafter I have constructed, my son have obtained the permission, and they have constructed a G+2 RCC building over the said plot of land. And now, Your Lordship, on Annexure.
It does not privacy appear that it is a case of 18.3. It is not a case of 18.3.
I have got the instruction, Lordship.
Yes.
The only basis of a map, Lordship, by the survey department, there was some encroachment on the road. Those encroachment were cleared and this has already been cleared. It has already been cleared.
So any contemplated eviction process?
No, Lordship, the eviction is already completed, but they have not touched any Mediland, any Patta land.
What is the present
was
status
just-
as of now?
Status
As of now,
is
Your Lordship.
already been
At this hour?
At this hour, Your Lordship, as I was informed, and today morning, the respondent number 2 and respondent number 3 officials has arrived. They were conducting the survey eviction process, Your Lordship, and they were asking for the documents and they were waiting for the court order. That was my instruction, Lordship.
But just now, Lordship, I have received the instructions that they have not touched the Patta land, the encroached land over the road. Those were touched. Some small
Was there any boundary wall?
that I have not inquired, but regarding this present petitioner, I have
Do
inquired.
you have a boundary wall?
Yes, Your Lordship. If Your Lordship comes to
Any photo?
yes, Lordship.
Small
Page,
slope was there, that was.
page 46, if Your Lordship come,
Page 46.
Annexure 10, this is the house, Your Lordship. There's a gate in front, Your Lordship.
And this is the west side.
This is the way.
This is the road.
And the front facing the road, Your Lordship. This is 46. This is the house, Your Lordship. There's a gate, Your Lordship.
I have been told some small shop was there, most probably this Tin Sali, Lordship, it was demolished. But they have not touched any house.
The Lordship comes to page number 41. The eviction notice that has been served, Your Lordship. The eviction.
Yes, sir. No, I am just
Yes,
asking
Your Lordship. Yes, Your
that.
Lordship. Annexure 8, Your Lordship, page 41. That is type copy.
No, I am reading it. The particular one, I am
Yes, 46,
reading
Your
it.
Lordship. 42, Your Lordship.
7 lesser.
But it was not touched, Lordship. That was the instruction, specific instruction over telephone. There no houses were demolished. No Patta land was touched. Only the encroached part. Some small parts were encroached.
No, Mr. Ali, this shop is beyond
Apparently,
the
Lordship,
beyond the
beyond-
drain. Beyond the drain.
No, in this.
The
left hand side, Your Lordship.
right hand side, right hand. Page 46.
Yes. As regards this, we are not.
You are not concerned with this.
Not
These
concerned
are
with-
demolished. I have been told that regarding the present
But,
petition,
Your
only
Lordship,
small shop was there.
Whatever has been done is done. The status quo then. Status quo is on.
There have been. There have
Status
been
quo.
Yes, Lordship.
Status quo
Status
then.
quo will be done.
Why?
No. Lordship, and one more, if I may draw your Lordship attention.
No, first let us see. Then you will answer
Yes.
Mr. Borpuzari's query. Maintainability.
Lordship will kindly see, my lord, the schedule of the land at page 30. This land has been purchased by the writ petitioner. Kindly see, my lord. Schedule of the land, page 30. 7 lesser of land included so and so, covered by DAG number 1663, patta number 590 of village. So it is a Miadi patta land. No dispute to it. Admitted position. Then Lordship will kindly see the impute notice. Definitely. Impute notice. Now this is addressed to Samia Khatun. She is the writ petitioner out here. Yardara Apunak Jono Jaja Ulubai Muza Ulubai Gao Sorkari. Lordship kindly mark this. Sorkari 1147 number Dagor. Gurado Rasta Himani Dharano Fondor. বেদুখন মুক্ত কৰাৰ বাবে অহা ইংৰাজী ইমান তাৰিখৰ ভিতৰত মুক্ত কৰি দিয়াৰ বাবে এই জাননী যোগে জনোৱা হ'ল অন্যথা অসম ভূমি নিৰ্ধাৰণ 18(3) মতে অনুযায়ী ব্যৱস্থা লোৱা হ'ব now this is with regard to land reserved for roads now in the meantime Salakuddin has come my lord that defiance court order if a person is in occupation of any my lord government land then if my lord, notice is mandatory, and he will have the right, my lord, to raise his bona fide claim of right over the plot of land. So and so. Then, my lord, here is a case where we can go for forthwith eviction. Even this notice is redundant because he is transgressing into the land which is otherwise reserved for road. That is a road. It is not in dispute in the writ petition that the part and parcel of land which falls under 1147 is not a mere, my lord, ordinary government land. It is a roadside land. In fact, it is a road.
No,
now, that's me, my lord. Now, if we see, my lord, rule 18.2, 18.2 is clear. When such person has entered into possession of government coastland or wasteland or estate over which no person has acquired the right of a proprietor, landholder, or settlement holder, or that has been previously reserved for road or roadside land and for grazing, so and so, he may be ejected or ordered to vacate the land forthwith. Now,
this court has held on that 18 to roadside land, roadside grazing reserve, all these are roadside land, reserved already in the land records. We have held, but question is, he is also a patta holder. Near that, let us find out. Mr. Sharma has already taken instruction that whatever is done has been done.
So it has been done.
As on status quo, at this point of time, we maintain, you come up with the instruction.
At this
At least this petitioner has a Miadi Patta plot of land. Maybe some dispute regarding yes, encroaching 1 foot, 2 foot, 3 foot. Let us find out that, then we'll recall that order.
Let them go to
Had he not been a bona fide occupier of a plot of land, we'd have not. You have seen that this court is not entered any petition, but here is a case that she is there. If you count, if she is holding possession of 8 lessers, we'll directly to demolish the building also. But before that, at least the right under Article 21 is there, and 300A is there. Hard.
I could have perceived the situation
in a similar case,
occupation of a government land.
in a similar situation, the lordship has passed.
Heard Mr. A.I. Ali, learned counsel for the petitioner.
In this case, your lordship has.
Only my prayer is the your lordship can pass the status quo order that relates to
Only petitioner, only petitioner.
And in fact, the petitioner has, I should not spell it.
Yes.
He has, well, not filed any representation, although she has made a statement that she has filed a representation, but it is somebody else.
Her son, you know. She and her son has been mentioned in the petition. And the petition is signed by her son, Navajit Talukdar. Not the her relative.
G. Hazarika, standing as Revenue Department, response number 1.
By somebody else.
A neighbor.
We We're not going to that now, right now. Additional H. Sharma, you are paying for whom? Okay, you are revenue. Oh, since morning I have been dictating the name of Hazarika. R. Barbujay, Standing House, Revenue and Disaster Management Department for the response number 1.
One, my lord.
H. Sharma, Lanet, Additional Senior Government Advocate Assam for the response number 2 and 3. Mr. Dhar, you are for whom? You are for the road. Okay.
My role is not yet, my lord.
R. Dhar, Lanet, Standing Council PWD for the response number 4 and 5. Full stop. The petitioner has claimed that she is the landowner of a plot of land measuring 0.94 R within bracket. Seven lessons.
Lordship, the appropriate will be 0.72 R, your lordship, because although the petitioner has purchased 7 lessons of land, your lordship, during mutation, the circle officer came to a conclusion that she was in possession of 0.72 R. So 0.72 R was mutated in the name of the
Where? Okay.
Your lordship, in
Okay.
Annexure 4, page 33.
33.
It's not mutation, and the complete mutation order isn't me, your lordship. This is the complete mutation order.
Anyway, you tell me, page 33.
Page 33, your lordship. This
Okay.
is type
Has
copy.
claimed it on the strength of a registered sale deed, the petitioner has become a mutation order dated 16/8/2012, the petitioner becomes a landowner, had become the owner of a plot of land measuring 0.72 R, covered by DAG number 1663 and Pata number 590, at situated village Ulubari, Gaon, Mauja Ulubari, Guwahati Revenue Circle subject plot, wherein after obtaining a no objection certificate, as per the registered sale deed, Annexure 3, there existed government land on the west side of the subject plot. The petitioner has approached this court. Petitioner has stated that a planning permit was issued. Planning permit stroke no objection certificate for construction was issued by the GMDA and GMC. And on the strength of those, the petitioner has constructed G+2 building on the subject plot. The petitioner has approached this court after being served with an eviction notice dated 4/11/2024 by the respondent number 3, whereby the petitioner has been asked to vacate land falling within government DAG number 1147 for the purpose of ascertaining the boundary of the road by 13/11/2024. Mr. Ali, learned counsel for the petitioner, has submitted that the land area in possession of the petitioner is not beyond 0.72 R. And the subject plot is surrounded by boundary walls except on the western side where there exists a road. It is his specific contention that the petitioner is not in occupation of any area of land falling within government Act number 1147 2000. Oh, sorry, 1147. Stop. Mr. Sarmal and the additional senior government advocate appearing for the respondent number 2 and 3 has submitted that as per the oral instructions received, oral or telephonic instruction received by him, comma, but
no any Medipatta land was touched.
no periodic patta land has been touched in the eviction process that is going on.
Survey and regarding the road, the survey was done on the basis of the map of the survey department.
And the eviction process is carried out on the basis of the survey map and the revenue records available. And only the encroached part of the road has been cleared. Full stop. The matter would require further consideration. Issue notice returnable and so as 2nd December. In view of the arrival contentions advanced by the contentions made by the learned counsel for the parties, and more particularly having regard to the fact that the petitioner is owner of a periodic patta land measuring 0.72 R. That is the subject plot, comma, the parties shall maintain status quo as the parties herein shall maintain status quo till the in respect of the subject plot and on the western side of the subject plot till the returnable date. Subject plots and on the western side of the subject plot. Only confined to that. You come up with that. Extra copies. Extra copies by tomorrow.
Items 35 to 37 for admission.
May it please your lordship.
Your lordship, in respect to this, your lordship, I have given instruction by Mr. P.P. Das.
35, 36, this.
Yes, your
Yes.
lordship. He is the engaged counsel, Mr. P.P. Das, but he has undergone a surgery with respect to gallbladder operation, lordship. So he couldn't appear in this
Okay.
court. So he has asked me to sort for an adjournment. I was just being instructed, so I couldn't inform the.
Okay,
counsel. I didn't knew she was the engaged counsel.
At Chakraborty. Learned counsel for the petitioners.
In
Same
30
petitioners, right?
35 and 37 lordships. He is there in 36.
Oh, you were there. For the petitioners in 35 and 36 and Mr. M. Nath, learned senior counsel, assisted by Mr. A. Bhorasaiji, learned counsel for the petitioner in 36 are present. So Mr. A. I. Ali, learned counsel, appearing for Mr. P.P. Das, learned counsel for the private respondents, has submitted that Mr. Das has undergone a surgery recently and is on medical leave. Mr. Ali has thus prayed that the cases be listed.
Sorry, lordship.
No, it is your convenience.
So after 2 weeks.
2 weeks, first off. Mr. H. Sharma, and additional senior government advocate. Revenue, PR Mohanto, revenue. Dotto is there, as Dotto, standing as a Panchat. Why? They are inter-party. You were there. Panchat and Rural Development Department are in attendance. In view of the region cited for adjournment, let the cases be listed on December date.
Okay. Item 38.
May I please, ma'am? Look, non-payment of contractual bills, my lord.
Contractual dues.
Ma'am. 18 is the completion certificate.
Yes,
Page 18.
we have been sending it to bench 4. Bench 4 matter actually. Yes, PWD. Contractual dues, bench 4.
Bench 4, my lord. And my lord, this is a, here, though PWD is there, my lord, it's a transfer subject, BTC. So BTC comes in, my lord, I was just looking. for-
BDC is there, SR Rava.
Yes, sir. So,
Okay, anyway, it is bench 4.
Bench 4, my lord. My lord.
Okay, P.K. Muniz for the petitioner. Ardor Public Soin Sakol likha ase. PTC P. Hazarika representing SR Rava. And M. Borman. Learned councils, respondent also have submitted that the subject matter of this writ petition is contractual dues. Non-payment of contractual dues, non-payment as regards a contract work. And the subject matter pertains to bench 4. In view of the above submission made by the Learned Council for the parties, the registry to look into the matter as regards subject matter falling within the purview of bench 4 and place the case thereafter before the appropriate bench.
39 is also similar.
Same. 39 same.
Item 40.
Lordship, kindly refer to page 45. Similar non-compliance of the order passed by the.
Let me, that is not presented before me for correction.
Not similar yesterday what has been decided. It's
So-
similar issue.
No, let it be complete and upload it, then we can pass the order.
Lordship, and this can be kept pending until that order comes.
Well, it's an independent, what submission made by the other side, I have no idea.
Let-
I am agreeing against the.
No, which page you are?
Page 45, Lordship. 41 is the order
40?
passed, 45.
5.
41 is the order passed.
41 is the order passed
41 is the order passed.
by the commission.
Commission which is not been complied with. They have not approached.
Here what happened, there is a order passed by this honorable court on my lord 29/7/2024, my lord, directed the official of the GDA to furnish the information as sought for, my lord. And accordingly, they took time, my lord. It was otherwise they have to appear for.
No, State Information Commission, what is the order?
My lord, subsequently.
Second appeal, what is the order?
Second one is directed to furnish the information, my lord.
Right. Thereafter, you
He-
approached
he has-
the,
He has not complied with the order.
no, thereafter again you approached the State Information Commission.
We approached this honorable court, my lord.
Directly came to this before the honorable.
Now, what happened?
This is the only-
They defined the court's order and they furnished this certain information, but without furnishing two of the vital information, well, an affidavit.
Yes.
Reply had been filed by us, my lord, on 10/9/2024.
So-
Here, my lord,
Mr. Goswami, he is asking, he is submitting not to your detriment.
my lord,
He is submitting for your benefit only.
my lord,
Yesterday, after a long hearing, we have disposed of a matter
my lord,
saying that
my lord.
the commission has power to implement its own order,
My lord,
right?
my lord.
So dictated for more than 3 hours, the order has not come yet.
My lord, I have no.
And that is why
I have
he
no-
has submitted that this repetition will be covered by that judgment. And then if you file a complaint under 18, they will look into it and will implement. That is what he has intended. Subject to any further decision by higher forum. We have hold that 18, that State Commission is not a teethless body,
My lord, my lord,
right?
my lord.
So you wait for some time,
my lord.
It will be your benefit, not to your detriment.
Otherwise, the authority has defined it.
No, because we have found that many writ petitions are coming
my lord.
with the grievance that after passing the second appellate order by the State Information
My
Commission,
lord.
authorities are not implementing. Let it be after some time when only one. How serious is the information?
Whatever the person.
How serious are the information?
The person.
For the
who
moment,
is-
for the moment. How serious?
There is a illegality committed, my lord. Everything will come out, my lord.
Mr. Goswami, for the moment I am saying. Whether it is a matter of the moment or it can wait.
My lord, definitely.
Then wait for 10 days
As per the order.
or 7 days. Okay, heard. Mr. Goswami, you Goswami, learned counsel for the petitioner. Mr. Chetri, you have
I'm for respondent 5 and 6.
5 and 6. Okay. You are seeking information from him.
My lord, he is defying the court, my lord.
Okay, okay. Mr. B.J. Talukdar, you can appear. Housing Urban. Housing, senior counsel assisted by so and so. P. Devi, learned counsel for the respondent 1, 2, and 3. Mr. B. Deka, learned standing counsel. D. Deka, learned standing counsel, State Information Commission, Assam Information Commission. For the respondent 4, A. Chetri, learned counsel for the respondent 4 and 5. Posted. List the case as sought for by the learned counsel for the party. List the case on. Give a date after 7-10 days. Fixed date. 20.
Hold on.
41.
May I question? In this case, the instruction was sought for whether my lord.
And Goswami.
Instruction has not been given.
Small instruction.
My lord. The instruction.
One is what?
Whether
This petitioner's Anganwadi is going to be closed or not, and whether any other.
As per their policy, new Anganwadi center is going to be established, model Anganwadi center. As per their policy, my lord.
Your land is very small.
So my lord, my humble submission, land area, this is.
No, I am only trying to find out whether your Anganwadi is going to be closed. Otherwise, you cannot have grievance. These are state facilities. If one more is established nearby, how you are going to be affected? These are state facilities.
This is right, man. Only that in their policy decision to establish a new Anganwadi center, we have no objection. But they are submitting in their affidavit, they are using our Anganwadi center's name, 165.
That is I have asked for.
That difficulties, because our in a surveyed area, my lord, 3.5
communicated.
Mr. Talda, you have to change your name. That is what their prayer is, from Dharmendra to Amitabh. That is one of the grievances. Take your instruction. Otherwise, this can be closed. Heard Mr. H.R. Sodri, Land Counsel for the petition. Mr. B.J. Talukdar, Land Senior Counsel, assisted by Ms. P. Devi, Land Counsel for the respondents, has submitted that the instructions, as called for by the order dated 28/10/2024 are yet to be received, and has sought for listing of the case on another date. The prayer made by Mr. Talukdar stance is allowed. List the case on.
72. Item 42.
So we are aggrieved by the transfer of an IMFL op shop to a place near my school.
Near your school?
Lordship.
What kind of school?
Lordship, it is the Halakura ME school, Lordship. The
Recognized kind of school?
Yes.
Recognized kind of school?
Recognized school, Lordship.
If your lordship takes up the exercise manual for a minute, lordship,
So what is your grievance? What is the distance?
the distance.
Huh?
We say that it is 100 and it is less than 150 meters from the school, which is given under 289, and it is also within a distance of 100 meters from the national highway.
100 meter from national highway.
National highway or the state highway, and 150
No,
from
no,
the
what
school.
is your contention? First,
Our contention, there are two. The first contention is that in our petition, we have stated that our the proposed location of the shop.
Huh? Hmm. My court master is informing me that I don't deal in liquor. Is it correct, Mr. Gogoi? Bench for matter.
Otherwise, dealing in liquor, I think is correct.
So this bench does not deal. Okay. MDAS petitioner who are present. Mr. Gogoi, is it correct? Bench 4.
Settlement liquor shop.
R.R. Gogoi, Land Standing Council, Excise Department, 1-2. Mr. Talda, Land Senior Council, State by MSP Devi, Council for Response number 3 and 4, and Mr. B.D. Daka, you private. For response number 5 are present. First of it is submitted by the Land Council for the parties that the subsequent of petition pertains to bench 4. So registered to look into the matter and list the case before the appropriate meets.
Lordship. Lordship, the petitioner already has an order of this honorable court in her favor. There is already an order of this honorable court in the petitioner's favor, Lordship. Lordship will find it at page 44 to 46 of the petition.
44 to 46.
46. Relevant portions are from 45 and 46.
Anjali Ghosh.
Lordship.
Yes.
Lordship, in this case, the petition was disposed of with a direction to the respondent number 5, which is the circle officer, Tezpur Sadar Revenue Circle, to demarcate the land legitimately belonging to the petitioner, your lordship. But however, it was not done. Then the petitioner represented before the authorities along with a certified copy of the order. However, again, it was not done. So, my lord, the petitioner had to forward that, petitioner had to submit that representation again in front of the deputy commissioner. The deputy commissioner, your lordship, forwarded the representation of the petitioners, which your lordship will find at page 48 of the petition. Thereafter, the circle officer, Tezpur Sadar Revenue Circle.
48.
48, your lordship. The representation of the petitioner was forwarded. Then thereafter, your lordship, the circle officer, Tezpur Sadar Revenue Circle, replied to this communication by the DC, which my lord will find at page 51. The circle officer replied. Your lordship, in their reply, lordship will look at the second paragraph, vernacular version. Sorjobin Todantokrame জনাও যে মহাভৈৰৱ মৌজাৰ তেজপুৰ চহৰৰ দ্বিতীয় অংশৰ 1266 নং দাগৰ 4 কঠা 5 লেচা মাটিৰ অংশত শ্ৰী অঞ্জলি ঘোষ, পিতৃ ৰাখাল চন্দ্ৰ ঘোষ, শ্ৰী মানিক দত্তই বাঁহৰ বেৰা দখলত ৰাখিছে। উক্ত দাগৰে অংশত তেজপুৰ জিলা মাধ্যমিক শিক্ষা আৰু কৰ্মচাৰী সংস্থাই ঘৰ সাজি দখল কৰি থকা দেখা যায়। উক্ত 1266 নম্বৰ মাটিটো হুলা মাটি হয় আৰু উপায়ুক্ত মহোদয়ৰ সৈন্স তাৰিখৰ 15/10/2015 নম্বৰ গোহাৰি মৰ্মে উক্ত 1266 নম্বৰ দাগটো হুলা মাটি হিচাপে চিহ্নিত কৰা হয়। সৰজমিন তদন্ত কালত উক্ত মাটিৰ পশ্চিম দিশত, লৰ্ডশ্বিপ উইল নোট দিছ, পশ্চিম দিশত অৰ্থাৎ 1255, 56 আৰু 57 নম্বৰ দাগত এটি পুল কালভাৰ্ট থকা দেখা যায়, যিটো পুলৰ জৰিয়তে পানী বৈ যোৱাৰ ব্যৱস্থা আছে।
Your father is Rakhal Chandra Ghosh.
Rakhal Chandra Ghosh. So
And how much was allotment?
2 kathas, your lordship.
2 kathas.
Out
Out
of
of 4 katha, 5
5
lesa.
lesa. And your lordship.
So you are in possession of a part of land.
Yes, lordship.
Under within that 4 katha, 2 lesa.
Yes, lordship.
Now what is your grievance?
Your lordship,
How
when-
much under within your Bahar Vera?
Lordship, there were 2 kathas, and lordship will find it in their notice itself, issued by the circle officer, your lordship,
Where?
which lordship will find at page 41. This notice was issued before preferring the earlier petition, your lordship, but I have to show it to this court so that things are clear.
41.
1, your lordship.
Holar Mati. What is Holar Mati?
Tural wetlands. your
Huh?
lordship. Tural wetlands. The tural wetlands, your lordship. Water passes through that.
Holar
Drainage,
Mati means
natural drainage.
wetland.
Yes, yes, lordship. Natural drainage.
Natural drainage.
Yes, lord.
So, চাৰিকঠা মাটি প্ৰাকৃতিকভাৱে এটা হোলাৰ মাটি হয় বাহৰ বেৰা দি দখল কৰি থকা হৈছে okay what is the earlier order let us see
The first order, lordship will find at page 28.
no page 45
High Court's order. This is issued
this is no,
subsequent to this, your lordship, subsequent to this notice, wherein lordship, the settlement was made back in the year 2000, and lordship, the decision for settlement was taken in the year 1996.
occupying hola land
As per this notice, petitioner was occupying 4 kathas and 5 lesses land, your lordship, the whole land under DAG number 1266. But however, now lordship, they have changed their stand, your lordship. And this concern about Hola was lordship raised long back in the year 2007 itself, and Deputy Commissioner has considered it time and again, your lordship. And after considering, the order for demarcation was passed more than thrice, and once by this Honorable High Court as well.
so demarcation was done or not two
Not
kathas
done, your lordship.
huh
Some other area of land was done. Lordship, the area where the culvert stands, that area was demarcated, lordship. Lordship,
no your 2 katha has been demarcated or not demarcated
not demarcated, lordship, till now.
yes what
Since
Mr.
it
Bhandi
is not demarcated, the
you are
neighboring
doing
people are trying to.
come to page 46
Lordship, we file our affidavit, lordship.
They've already filed.
No, oh no, but you
file
have to
our
take,
affidavit.
you have to take note of the judgment or order also. Did you take note of that? Please see 46.
Lordship.
This writ petition is being disposed of by providing that the respondent shall not disturb the possession of the petitioner over the land measuring 2 kathas,
Lordship,
which
so
was settled with her deceased father by an order of settlement dated 18/8/2000. Now next, action if any in respect of other area of land under her possession be initiated by following the due process of law only after demarcating the boundary of the land legitimately belonging to the petition.
Lordship.
Did you
Lordship.
do it?
Lordship. Lordship.
Let us see your affidavit.
Lordship.
Hola is not coming now after this order. Hola or Molla, whatever, is not coming.
Settlement was made, your lordship,
Lordship,
much
I kindly
earlier.
come to our affidavit in
Affidavit,
paragraph number-
yes.
Paragraph number 4, lordship.
You are again bringing Hola
Lordship. My lord, it is the
in paragraph 4.
lordship.
Why
As
did not
per-
you contest at that point of time?
There is a notification, lordship, which are we.
Geographically is noticed the presently the
It only
state
came up
schedule
in the
land.
year 2015. 15 years after settlement, your lordship. The
Now,
process-
this is contrary to the 2 katha is there.
2 katha
You
is there.
demarcate first.
Lordship, then lordship, kindly turn to the page 6, paragraph 6, lordship.
6.
Lordship.
Here comes the twist. But this stand again is contrary.
1 minute, let me read. I cannot.
I apologize.
I have not.
I apologize.
You are allotted what, which dog?
1266, your lordship. And
1266.
we are not asking for 1267 anywhere in our petition.
Huh?
They have mentioned about 1267, but we never asked about 1267, your lordship. We never asked to demarcate 1260.
Now, what does it mean, Henry, Mr. Henry? Paragraph 6.
When the language.
Language.
The report that,
Original demarcated tag number 1266. Okay, original demarcated. But according to the petitioner's claim, to demarcate his 2 kata of land,
both the dark lordship, the 2 kata is.
I'm not very that sharp to understand. You please explain it to me.
As far as circular lordship may read, sir. That's with regard to the statement made in paragraph number so and so of the petition, that defendant respectfully stated that as per the report by the team originally demarcated the dark number 1266, but according to the petitioner's claim, the demarcate his 2 katas of land in dark number 1266 as 12267. And the dark number 1267 is the Miadi Patra land. As per the circle officer report, the petitioner created the boundary fencings in 2 katas of the land comprising the both the dark 1266 and 1267.
Lordship,
After demarcation, the schedule of the land.
Lordship, this is contrary to their stand because in the notice which was issued before the earlier petitioners referred, it was said that we are.
This statement is made after field inspection.
Yeah, Lordship.
This statement is made after at least some kind of a visit to the spot.
But Lordship.
Earlier is okay.
Yes, Lordship.
Earlier is okay.
Lordship,
maybe without any kind of
if kind
field inspection.
53 and 54.
But now, after field inspection, it is found that you are occupying in occupation of 1 kata out of 1266 and another 1 kata out of another plot.
Lordship, perusal of page 52, 53 and 54 will make things clearer. Page 52 has the trace map, your Lordship, of the repetition. Page 52, there is this trace map. Lordship will, if Lordship found.
Now, where this 1 kata is gone then?
Lordship, let me submit. Lordship, in this 1266, if Lordship looks at towards the top of the area where 1266 is demarcated, here, Lordship, there is a curve, Lordship. Now, if Lordship looks at page 53, the area between the tin wall as well as the bamboo fencing, this is the curve area, Lordship. And now, and this is the land at page 53 is the land which was under possession of the petitioner. But however, Lordship, the demarcated land is somewhere else. It's at page 54.
Let them file a reply of this my affidavit if it is there.
Demarcated
Provision occupation of this your
they have already mentioned
1 kata.
Lordship, they have already mentioned that apart from the petitioner, one legal heir, so one Manik Datta, as well as one teachers association have been occupying land out of that dark number 1266. Lordship, in this photograph.
Then it is a case of encroachment by private person.
Yes, but your Lordship, since order was passed in 2000 and it was ordered that land records be corrected and patta be issued to the petitioner and demarcation be done and also like mutation be done, your Lordship. But it was not done. Since land record was not corrected, your Lordship, and demarcation was not done. So petitioner actually, Lordship, cannot say from like exactly from where they are trying to dispossess the petitioner. And the circle officer, for reasons unknown to the petitioner, your Lordship, are sitting over their duties. They have not been demarcating the land since the year 2000.
No, they are saying that you are in possession of 1 kata.
Yes, Lordship.
Of dark number 1266.
Yes, Lordship.
And which should have been 2 kata.
2 katas. But
Earlier,
That
they were
is,
saying
that is
that,
why I'm asking you the question that where is you are in the at the place. You must know where this one katha is there. Leave aside hola.
Lordship, let me rephrase my submission. So, Lordship, petitioner is under possession of 2 kathas. It was, but your Lordship, the legal heirs of Manik Datta have been trying to dispossess the petitioner from long time back, your Lordship. And due to that, the petitioner might not exactly have 2 kathas, but it is still more than 1.5 kathas, your Lordship. Firstly. Secondly, in the year 2007, their stand was that, in the year 2019, their stand was that I'm in occupation of, I'm in possession of the whole land. In 2022, they said I'm occupying more than 2 kathas of land. Now they are saying I'm occupying less than like only 1 katha of land. Lordship, all these things are actually delaying the process, nothing else, your Lordship.
And
The
it
proper
is a
demarcation has
jurisdiction
not
of
been
not this read code then. Some your one katha is under occupation of another Manik Datta.
Lordship,
and
that is
you are
not
in
a submission.
occupation of government, another plot of land of measuring 1 katha. Somebody, that is their report, they are saying.
Yes.
You are saying differently. They are saying differently.
Yes.
Who will decide? If your 1 katha is enclosed by another person, Manik Datta, is it a case of read? No.
Lordship,
So far as your occupation about other land, 1 katha, these are not. File your reply clarifying that.
Lordship. Lordship, basically the office of the circle officer, Lordship, if they had demarcated the land as per order of this honorable court, at that time, Lordship, 2 kathas were under possession of the petitioner. But since they did not demarcate their Lordship, and now they are saying the petitioner has to verify whether he has 1 kathas now or whether 2 kathas are still there. But your Lordship, there are 2 different plots of land which have been demarcated. One was under the possession of the petitioner, that still remains. But however, they have demarcated another area over the
Counsel, otherwise, when demarcation is directed, suppose this court of a particular person, the land area in his possession can only be measured without anything else. The person cannot enter into the official event, cannot enter into for measurement of land otherwise. The land under the possession of the particular person, that can be measured. And it is found that 1266 dag out in respect of the petitioner is in possession of 1 katha. That is what they are saying, as I have understood. You, and these are matters which are to be decided at the field level. Under
But
the
since there is no mutation order in favor of the petitioner, so petitioner cannot approach the civil court, your Lordship. It was not mutated. There is no demarcation.
Not mutated.
Not mutated. Demarcation was not done. After demarcation,
Why not mutated?
After demarcation, land records were to be corrected, your Lordship. Thereafter, only the process of mutation would have started. Firstly, they were citing reasons of rain, your Lordship. That due to rainy season, the handing over possession and demarcation could not be done. It's on record. Then they said that petitioner is occupying more land than what was settled with the petitioner. That's why they could not demarcate. Now they are saying only 1 katha of land is there with the petitioner, your Lordship. So basically, the petitioner has nowhere to go, your Lordship, because the office of the circle officer has been changing their stand again and again, your Lordship. And moreover, your Lordship, the notice for demarcation, which was issued, it was again sent to the legal heirs of Manik Datta. Copy of the same was handed over to us, your Lordship. However, the case was referred by us. The settlement was made in favor of the petitioner. However, notice was issued to Manik Datta.
Mr. Counsel, when I am reading, please stop making submission. By making your submission, you are not clearing the air or cloud. So Tukata has not yet been settled in your favor or in your father's favor.
It has been settled, Your Lordship.
No, allotment is one.
Your Lordship.
Land Advisory Committee is not the final authority.
Lordship, it is settled also.
Please, I have understood your case now. It is a deputy commissioner who is the final authority.
Your Lordship.
That is a recommending authority. That land advisory does not have any statutory status
In 2002,
under Assam Land and Revenue Regulation 1886. Am I clear?
Your Lordship.
Now come to page 36. It is a proposal.
Thereafter, Your Lordship.
It is a proposal, Mr. Counsel. And if you are projecting something to get the order from this court, then I'm sorry.
Page 36.
Right has not been crystallized in your favor as on date. You are in limbo.
Lordship, firstly,
File your reply.
Your Lordship.
It is not settled land.
Upon payment of premium,
It
Lordship,
is not yet settled.
Lordship. I'll-
Because did you pay premium?
Yes, Lordship, I paid.
But still the deputy commissioner ordered inquiry. He was not taking the process to its logical conclusion because of HOLA.
But Lordship, HOLA.
Land Advisory Committee does not have any authority to decide about HOLA.
HOLA was declared in the year 2015. Land was settled in the year 2000. Your Lordship.
How can, Mr. Page 36, 2007, don't makes, once this court reads that, court takes note of everything. Page 36, 2007, HOLA. Don't make such submission.
But till
Please,
then, till then,
HOLA mati ullekh nasil.
Lordship, till then notification was not issued. It was only said by the circle officer. Notification was issued as they mentioned in the affidavit. Only in the
Ottoman HOLA, that means that 2007, Sakra Bikhay HOLA mati buli protibidan dise 2007.
কিন্তু আবেদন প্ৰস্তাৱত হোলা মাটিৰ উল্লেখ নাছিল।
Page 37 also. Lordship.
36.
Even 37 also.
37 is also after that.
The two kata land awards of.
So read 36.
36 is there, the land. to-
Clear order.
Not been handed over to the petitioner.
Yes,
Yeah, this is clearly
it was
stated.
not handed over. Only deposit of premium does not crystallize the right in favor of the petitioner. Anyway, your name, please. File your reply.
Yes, Lord. The border.
You are not a landowner, sir. There was a proposal of the Land Advisory Committee to allot the land, and there was an observation to deposit, but the Deputy Commissioner has not issued any settlement.
Lordship, at page 33.
33.
Lordship kindly looks at page 33. I think, Lordship, I may be wrong, but I believe that's the settlement order, Lordship. Lordship will look at second and third paragraph.
But that has not been finalized. জমা দিয়ে।
Third paragraph, Your Lordship. সেয়ে মহাভৈৰৱ মৌজাৰ চহৰৰ দ্বিতীয় অংশৰ 1284 নঙৰ খ অংশৰ 2 কথা চৰকাৰী মাটি ৰাখালচ্যুত চন্দ্ৰ ঘোষ পিতৃ মিত্ৰ মথুৰা চন্দ্ৰ ঘোষৰ নামত
When it
বন্দোবস্তিৰ
was-
আদেশ দিয়া হ'ল। Already ordered, Your Lordship. বন্দোবস্তিৰ আদেশ দিয়া হ'ল। The third paragraph, Your Lordship, last line. Firstly, settlement was proposed.
That was there, Mr.
Yes,
Hendrik.
After that.
Then why he is writing differently?
Lordship, because the circle officer does not want to demarcate the boundary of the land, because otherwise some
No,
other
when
things might-
HOLA was declared,
only in the year 2015.
where
They have-
from you are saying?
It's in the affidavit filed by themselves, Your Lordship.
Let us see.
At page 77 and 78, the notification. It was only issued in the 77 and 78. The
They are annexer.
Lordship. Your Lordship.
Huh?
Annexer.
Annexer.
Last affidavit.
Last affidavit means?
Lordship, affidavit filed by the government. Affidavit in opposition, Your Lordship. The last and second last page. Date is 2015, Your Lordship. So had the circle officer corrected the land records back in the year 2002 when it was ordered, this notification would have been different, Your Lordship. It would have excluded the land settled with the father of the petition.
No, what is this, sir? This is part of 77.
Yes, sir.
1 minute. Kajal,
Moreover, Lordship, I apologize.
Mr. Gogoi, sorry, Henry, you produced this notification, page 77. RSG 59410 31 5 1995.
In my lord, that
In Assamese,
Lord,
second para. You produce all this. First para document, second para document. Why you have referred to this? Let us see which paragraph.
paragraph 4.
You produce this file. Produce this file because affidavit will not serve any purpose. Half-baked thing is not. If it is not HOLA, if it is HOLA in only in 2015, the petitioner has a case. And if the HOLA is before that allotment, then petitioner does not have any case. Because contrary to HOLA, no allotment can be made.
That is true.
Right? A process is already there in the revenue records. Then it is a mere declaration or notification in 2015. But HOLA is already there. No allotment. As simple as that. You produce the file. Your affidavit will not do. Court will scratch the hair again for another 1-2 years. Heard Mr. D. Bora, Learned Counsel for the petitioner. Pima R. Mohanto, Learned Standing Counsel, Revenue and Disaster Management Department, 1 and 2, J. Hendik, Learned Counsel, Junior Government Assam for the response 3, 4, and 5. First of having regard to the submissions advanced by the Learned Counsel for the parties, it appears that to consider the issue in an effective manner, issues raised in this petition in an effective manner, it appears that the concerned records leading to passing of the order bearing number running page 76 or 77. Passing of the notice dated, notice number so dated 15/10/2015 appears necessary. Mr. Hendik, Learned Counsel for the Learned so shall produce the record. Shall obtain and produce the record on the next date of listing. Yes, as prayed for, please the case. Fine.
Lordship will kindly fix a date.
2 weeks.
I'll have to travel from Tezpur, Lordship.
You are from Tezpur?
Yes, Lordship.
Okay. December
Lordship.
4th or 6th? Friday?
Lordship.
Okay,
Most
6th.
convenient to be.
6.
I'm very much obliged, Lordship.
Item 45.
Yes, Mr. Sinha.
Yes, no, last occasion we have filed affidavit in opposition against the affidavit of the respondent number 5. There is very we have to correct it, my lord. Many, my lord, the wrong word is mistake.
I don't think that it is not possible. Your
Yes, my lord. Also, my lord.
Ah,
That I will
anything.
and refile, my lord.
Moreover, my lord, in this matter, my lord, petitioner, my lord, challenged the order passed by deputy registrar. If the order, my lord, disputed question of fact involved with the applicable order, my lord. So under 113, my lord, there's a remedy, my lord. So instead of approaching directly under
113 is what?
cooperative, the act.
That appeal, my lord.
Huh?
Appeal. That
The
appeal
private
111 is appeal.
Ah.
Private
But he's
respondent
submitting.
number, my lord, private respondent number 5, I'm representing, my lord. I'm challenging, my lord, the assistant registrar, my lord. They have not allowing me to giving voting right, even not member, my deleted, my lord. And I'm 111, my lord. I'm filing appeal before the deputy registrar. And deputy registrar considered my peers and rejected their order passed by the ARCS. Then they directly approached before the standing court. Whereas 113, my lord, there is a appealable of this order, my lord. So instead of disputed question law also involved in this matter, instead of keeping this matter, Lordship may fix another date, Lordship may hear the matter and dispose of the matter. Instead of further allowing to amend their application.
Your deletion of your name as a shareholder.
Yes, member, my lord.
As a member, shareholder
Shareholder.
of a cooperative society.
Cooperative society.
Deputy registrar has passed that order under what power?
There's a notification I have enclosed here, my lord.
Okay.
Yes.
Is it there?
Yes, I am enclosed, my lord.
In your affidavit of opposition?
Yes, my lord. Lordship will find in my affidavit of opposition 118, my lord.
118.
My learned friend Talukdar. Zonal register, my lord. Sorry. MP in order for zonal register. Serial number 2.
And impugn order is passed by
Zonal
Jonel.
register.
Joint register.
Zonal joint register. So 111, there is a power, my lord, for notification. So council representing the cooperative society, he might enlighten on this call.
That already, my lord, is there. I'm not on that. Whether the my lord, order passed by, not order, my lord. The letter issued by the ARCS is appealable. That is your lordship will decide.
No, 1 minute left.
Yes, my lord.
This is a new thing, so.
Yes, my lord. The lordship will find 111.
Doubtful that an appeal is maintainable. Will.
Yes, my lord. Yes, my lord.
Lordship takes them. Yes, my lord. On this point, my lord.
In the meantime, my lord, we will be allowed to withdraw the affidavit in reply file, and we have to be given liberty to file the affidavit in opposition.
Okay. Yes.
Yes, my lord. That may be.
Mr. Sinha learned, B. Sinha learned counsel for the petitioner. Miss.
Here on behalf of Mr. S.K.
S.K. Talaja. Standing Counsel Cooperation Department, Mr. P.K. Dekal learning counsel for the respondent number 5. Post of Mr. Sinha has submitted that the affidavit in reply filed on behalf of the petitioner in the so a number of inadvertent mistakes stroke errors
Yes, ma'am.
have crept in, and therefore he may be permitted to withdraw the said affidavit reply in order to file a fresh affidavit in reply, free of any errors, stroke mistakes.
Obliged, my lord.
So, and the leave sought for by Mr. Sinha is not objected to by the learned counsel for the respondents. Post of the leave so sought for, comma, is allowed. The petitioner shall file a fresh affidavit in reply within 1 week. Within 1 week from today. Post of Clara, as sought for and agreed to by the learned counsel for the party, leaves the case on interim order passed in the interlocutory application. I so shall continue till the next date.
Obliged.
Interesting. 118, right?
Yes.
182. 118. Interesting question.
Item number 14 and lordship appear for respondent number 8. Lordship, captive elephant case, your lordship.
Okay, choose a date in the next week.
3rd December.
So can it be on 5th or 6th December?
Okay.
5th.
5th, okay.
Lordship in the admission column, Lordship, otherwise pleadings are
Okay, in
complete.
the admission column. The 49. P.
P. Barua.
Borua, petitioners. And Gautam,
respondent number 8, your lordship.
respondent number 8.
And you, Pathak, I'm appearing on behalf of senior counsel, Mr.
EU Pathak. Learned counsel for respondent number 2, 3, 4, 5. We are not recording the names of the senior counsel who are not present.
Yes.
We are recording the counsel who are present. So you, Pathak, your name is there in the call list.
I'm there.
2, 4, 2, 3, 4, 5, and 6. Any union? Okay. Are present. As sought for by the learned counsel for the parties, list the case. Which one?
49.
5th December.
5
5 December.
5th December. 5th December.
Is it an admission matter, Lordship?
In the admission column.
Deeply obliged.
With regard to item number 46,
Yes.
on the last occasion also it could not be taken up due to possible.
What to do?
Yes.
Okay, on the prayer of Mr. P.K. Munir, learned counsel for the petition, at least the case on so and so.
May I, can the matter be taken up at 2 on the date fixed?
No, we don't fix case. at two.
It's for the-
There is no precedent. And there will not be any.
My lord, item number 52, my lord, it may be taken up. Item number 52, my lord.
Yes, please tell me.
My lord, on 2nd of December, my lord.
Okay. You're a petitioner?
My lord.
Okay, Mr. S.
People S. Rahman.
S. Rahman, learned counsel on the prayer of so and so, list the case on 2nd December.
Item 53, your lordship, if it can be next week, your lordship. 53 of today's list.
Okay,
Freezing of bank account, your lordship.
okay. DDO. MS on the so and so, F. Hussein. Huh? Learned counsel for petition, list the case on DDO, fix it. Okay, 22.